the West Bengal SIR.
Issued some direction.
Yes, my lords. My lords, the problem with respect to logical discrepancies particularly continues to continue because of surname mismatches, because the same surname in West Bengal often has two different forms like Mukherjee and Mukhopadhyay. My lords, and additionally, on the ground, Aadhaar cards are not being accepted for these voters, even though they have otherwise been able to link themselves to the 2002 roll. There's an IA.
This will continue. We are in the in a 32 matter, we can't resolve all these issues.
My lords, my lords, I'm just praying for the IA to be listed, my lords. Just the IA.
See, your IAs are also endless. Every day some IA.
My lords, obliged. I
The idea
apologize.
is to stall everything. That's what.
My lords, just like if it could, because my lords, the main date is 23rd of February now. So my lords, if just the IA could be listed.
IA इनको देख लो क्या what is the urgency in the IA and उसको फिर Monday में आके.
I'm extremely grateful, my lords, and my apologies for mentioning again.
I also have a similar IA in a connected matter, my lords, Bengal, pertaining to Bengal SIR.
Again दोबारा से mentioning का एक नया रिवाज शुरू हो गया फिर. What is the problem? Why don't you file the case and then wait for the registry to list it?
My lords, may I make a mentioning? I apologize, my lords. My difficulty is that I have filed my application, but because the impediment is not allowed, I cannot move a mentioning. The respondent had also moved a mentioning for not to be deleted, but somehow the matter has not been listed today. My lord, I am suffering an interim order from this honorable. Despite not being a party, I am the successful auction purchaser. My lords, it will take 10 minutes if my lords may list it on Friday.
What is the date in the main case?
My lords, it was supposed to be listed on the 27th today. It is not in the list, my lord.
The matters of this first
Please,
bench.
please, my lord.
No, we'll find out what is the.
I'm very grateful.
Item 1, the award is 2012. My lords were pleased to consider, my lord, our request for reconsideration. It is that Tarsem judgment. 2012 is the award. No proceedings thereafter.
No, but award may be 2000. After that, what is the process? When the
No, nothing. Thereafter, after Tarsem Singh judgment, my lord, some other person who in the meanwhile gets, my lord, a collusive decree. My lord, once the award is passed under my lord, the act, it vests in us. So land cannot be transferred, sold anywhere. Now, two brothers go and get a collusive decree. A sells the property virtually to B. B approaches the court after Tarsem Singh judgment, praying for, my lord, interest and solution. My lord, your lordships, my lord, while deciding the review, my lord, where of the impression, my lord, which I have, my lord, mentioned, that in facts of that case, the difference was 100 crores. Thereafter, my lord, your lordships, my lord, the chief justice would recall, we placed on record that the total amount would be approximately 50,000 crores. My lords were pleased to issue notice, my lord. That is at page 520.
no, that's what we have issued notice and
Yes.
we are examining that matter. The point will be that what is the date of the judgment, the first judgment in the Punjab and Haryana High Court? That is probably 2000.
That is precisely your lordships are deciding in review. Which, my lord, we have given three scenarios. The first judgment of some iron and steel, golden iron and steel. Then, my lord, second judgment. The third is Tarsem Singh judgment, etc. My lord, what would be the scenario, my lord, in terms of financial implication? That's what, my lord, we have placed.
Right, that is true, but the owners after the this golden iron when the awards are passed, how to deprive those farmers?
They have
For
not,
that understandable.
they have not done anything after the awards were passed, and thereafter the land vested in the NHAI.
Right.
Correct, my lords? Now, I was
And
the
there is
erstwhile
a
owner.
long delay in raising their claim. For that, the principle is that you don't grant them interest. But the principal amount actually, at least if they were entitled in law, that should be paid.
Principal
Of
amount,
course, interest will be also a very heavy component. That's why I was trying to recollect. We decided in 2008.
correct, to the golden iron. My lord, that is precisely, my lords are deciding in, my lord, that application where, my lord, the notice is issued. Lord, I think, my lord, it
So
would be.
we can, We can decide it today itself. It should not, because these unnecessarily these matters are now, we are getting lot of complaints. People are facing harassment. They are not getting anything.
My Lord, Harris, my Lord, with profound respect, my Lord, they did not pray for anything after Tarsem Singh, my Lord, either the,
You are right. So two scenarios will emerge. One, that all those cases where the award is passed after the cutoff date of 2008, that is the date of the edition of Golden Iron. In principle, in law, they are entitled to solatium and interest as per the old act at that time, right?
my lords are right, but that is precisely, my lords are prima facie reconsidering. I am only requesting, let this be
What
heard
we are
with that.
reconsidering is not that they are not entitled to. What we are reconsidering is that can these stale claims be entertained, right?
The settled claims being unsettled, would set Indore Development Constitution bench.
So that answer will be that if a person of awardee of 2008, if he comes in 2018, then he definitely loses interest of 10 years. He will not be entitled to claim interest either on solicitation or as a statutory interest in terms of 20.
That can be one, my lord, decision your lordships may take. Subject to, my lord, our being persuaded, persuading your lordships to take other view.
Similarly, those where the acquisition took place prior to 2008, they will not be entitled to because the law was not clear. They themselves never came forward. They did not come forward. So prior to 2008, you can legitimately argue that they are not entitled to.
But can I give another perspective for your lordship's consideration? Golden Iron, my lord, is 2008, which entitled them, my lord, to solatium and interest. Here the award came in 2012, so they could have immediately challenged that I am not getting solatium and interest, though Golden Iron permits me. They did not do anything till 2021. In the meanwhile, the property changes hands, which according to us cannot, because from 2012,
No, on facts you may have a different case. On facts, this kind of transfer may be a fraud in law. That will be on case to case basis. Right now, we
not
are
on
only on a
principle. Yes.
In the case of ordinary land acquisition, we are talking of the 1894 Act. The view taken by this court is that mere delay in approaching will not deprive equality, but the court can balance the equities
And not granting interest.
interest.
Lord, I'm suggesting, my lord, subject to your lordship's approval, can this not be heard with the review? Lord, this is, in review, my lord, we are giving hypothetical situations. Here we have one concrete case, that this is how the resultant effect would be.
So, the effect is, we have to see the other part also, na? After
Kindly see that, but kindly, my lord, when the review is heard, my lord, your lordships were pleased to, my lord, allow us an open court hearing. Thereafter, notice is also issued. So, my lord, prima facie, my lord, your lordships would be at least considering, my lord, our case. Because the, my lord, if this is the way, my lord, we accept, my lord, then the total exchequer burden would be 50,000 crores. So what possibly, my lord, persuaded your lordships is that burden is only 200.
that is what the ambiguity we have noted. We have passed a detailed order a couple of days back, pointing out the kind of anomalous situation. A land which is abutting to existing road, and we are not using the word highway, abutting to a road, abutting to a state highway, which eventually you decide to make a national highway, and for expansion of that you acquire the land. That landowner does not get any solicium, does not get any interest.
Lord,
The land which is-
now everyone gets.
How everyone gets?
It's a matter of past stale claims which are coming after the judgment. That is, my lord, your lordship's examination, my lord, in the
Stale claim in the sense that yes,
12 to 21 is a stale claim.
No, not 21.
Because in 2012, he was protected by Golden Iron.
what is the date in that matter? I think we should finish it, Mr.
Yes, yes, my
If I may
lord.
clarify,
Lord, only
solatium was even raised in 2012, not decided and left open.
That
by
is
the
not
court.
granted, you didn't
Finding of
challenge
the
it, that's all I'm saying.
may not make submissions which are contrary to records. Number one. Number two, this business of brother and all that, Mala, this is first time raised, even otherwise.
It is only a family arrangement where the partition took place and one land has come to him. So his
How can it take place after it is?
brother has given no objection. It is not the entire piece of
It's
land. which has
vested
been-
in me in 2012. It
So
cannot.
right to claim compensation has been transferred.
But
Otherwise,
that
give
is
it.
only a family arrangement for compensation. Suppose if we challenge the acquisition on that ground that I am the owner, I have not been hired, this and that. There you are right.
I'll be able to show my family arrangement also,
by-
not for claiming further compensation.
2012, I raised the issue. Issue is not.
I'll show, my lord, the
All
land
submission
stands
is- I'm
transferred.
Sorry, my lords.
Anyway, but I can't argue, my lord, inter se. Please see page 522 is the order passed by your lordships in that review, my lord. But kindly have it on any other day, my lord, but this needs final adjudication.
What is the date?
My lord, date is not,
My lords.
Opponent number one at 23rd February.
Well, there's one more aspect, my lords. In identical scenario, I thought I had raised it in 2012, not considered. Reason, another I'll answer if I'll try 30 seconds of my lords. I could not have challenged it in 3G because arbitrator, it is their own submission in hundreds of cases that arbitrator cannot go beyond the scope of the act, and that day 3G existed in law, arbitrator could have done nothing. That is the submission in hundreds of cases that they make.
But for
Because
golden iron.
statutory law. Now, second aspect. As regards this 2012, we were promised that it will be considered at later time. That is the finding of writ petition and in writ appeal. Well, it is another aspect that I kept quiet, did nothing. I raised it at the first available opportunity based on Madras High Court. So, well, I can't be made running like this for years together. Another aspect, well, somebody in the case of Valmik Kedu Kandekar, first time they filed claim for compensation in 2019. My writ is also 2019 where I had raised in 2012. At least in cases like mine may not be issuing notice, well, that's one humble submission. In Keju Kandekar, my lord directed the deposit of amount in this court. My lord, the same may be done here also at least. If my lords are issuing notice.
How does it will make any difference?
we cannot run away.
Sorry, my lord, that's all. Well, that's only that much respect. If my lords are
Amount
considering.
they will have to pay, then once we determine the amount, we will have to pay. We are only on the point of, we are fixing a date for.
No, my lords, kindly see. It is Keju Kandekar writ petition, first time filed, Solatium claimed in 2020. Legal aspect on that.
Can I have the
aspect is
copy,
other.
please? If you don't know.
The problem is that why don't we fix dates in these cases?
I do not know what are the facts of that case, my lord.
Sir, it is identical,
You
2019.
should- I should have the copy at least.
We are not even issuing notice, we are simply adjourning it, tagging with those matters.
Lord, only one thing, my lord, there is a contempt petition filed by them. That they may not precipitate.
Just get the,
We'll get it adjourned, my lord.
Item 1 and 38 I call are identical.
a notice has been issued probably. Okay. Anyway, in all these matters.
Yes, my lord, here I'm thankful, my lord, notice is issued. And your lordships were pleased to tag it with the,
RPC number 2528 of 2025. First, all these matters. At number 1 in the post list on 23rd February. What is the day on 23rd February? 23rd is Tuesday. Monday, sorry, Monday. Huh? Okay. खत्म करिए वो जो शिमला से भेज देंगे
my lords are issuing notice, my lord, because in the order shown by him, notice is issued. He is here, my lord, I am not, notice doesn't add anything more to it.
You see, notice he is already there.
No, certainly, but my lord, then he may make a statement that he will not precipitate contempt.
You deposit the amount there.
Yes.
Meanwhile, if the entire amount
That
is
might
deposited
become a
with
precedent, my lord, I have no difficulty.
the executing court, the content posting will be kept in a bench.
In
Then, my lord, your lordship,
Kind of solace to the client, that's all.
or only a minute.
And this earnest prayer that some kind of solace to the client if amount is deposited.
You have said that if the entire amount is deposited, then contempt will be kept in
No,
the
my lord, your
client.
lordship, my lord, my learned friend relied upon this order. Please have a look at the order, my lord, in Valmik Kedu Kandekar. Your lordships were pleased to direct that you deposit the amount. On such deposit, the direction shall remain stay. So then kindly not follow.
Same one.
Grateful.
It also same one, right?
No, 1 and 38 both.
1 and 30.
Item 1 and 38.
But you both,
38 is the main matter, listed wrongly. Obliged.
Grateful.
Lordship. This public interest litigation, Lordship, seeking implementation of judgment passed in 2002 and 2012, and and more many other judgments which is passed by
we
the
don't require a PIL for this issue, sir. I know how to handle it administratively.
Lordship. Only there are 10.5 judges per million in this country.
We are aware of
This
everything.
Honorable Court has already given many directions to the Lordship. We are seeking just a strict direction from this Honorable Court to implement this, because this Honorable Court is also
Right, thank you very much. We don't require any judicial intervention. The issue raised, sought to be raised in this petition essentially requires has to be dealt with on administrative side by the Chief Justice of India in association with Chief Justice of the High Courts and other stakeholders. No judicial interference is required in the matter. Disposal.
Wait, please. In item 3, a
Yes.
similar issue is pending consideration before your lordships. Because I'm requesting for the same order at page 36. Direction is at 37, my lords. This is with respect to, my lords, whether the Bar Association is,
Mr. Balla, your complex is outside the court complex.
that's right. Yes, but
You
no,
are
lord,
part of the same court complex.
but discharging the same function, my lords, at the end of the day.
No, normally in the judicial court complex,
Yes,
when there is a bar room, there is a library, this area entire, even including canteen or basic facility, that we expect the government to pay electricity charge.
please.
But if adjoining to or outside the court complex, if the lawyers construct their own hall, their chambers or any other facility, how the government will bear that?
It's limited only to the office of the Bar Association. As far as the chambers are concerned, it's a separate issue altogether. But at least the office of the Bar Association, and there can be this thing to it, my lords, that air conditioning and all, as done in the Madhya Pradesh judgment, that the state will verify at to what extent the amount as far as the electricity bill is concerned has to be borne by the state. Because I understand that it's outside, but at times, my lords, there, as far as the space is concerned, there might not be some space within the court premises. And
This has become a very problematic issue.
my lords, I understand. I understand.
Lawyers will first ask for the free land, then they ask for the governments to funding for the construction of chambers or the facility, then they say we will not pay electricity also. Then they would like to have, of course, the best of the air conditioning and all.
I will not press that, my lords, as far as air conditioning is concerned. Only on the larger issue, my lords, that since this issue is pending consideration before your lordships, two petitions are pending.
Issue notice tagged with SLK number 13331 of 2024.
Because there is a status quo order in the other two matters, my lords.
Will decide these matters at the earliest. Both the matters are ordered to be listed on so and so day.
I'm deeply.
Milord, Telangana has already introduced and enhanced the age to 61 years, Milord. Two issues, Milord. First is with regard to the enhancement of age, Milord, and second, re-employment, Milord. Milord, if sees the order, Milord, page 208, my lords have passed an end.
No, what is the age of retirement under the rules?
My lord, in fact, rule is silent, my lord, which your lordship will find in Jharkhand. The rule is silent, my lord. In second, my lord, page 82, my lord, I have mentioned that. Kindly see, my lord, page 82, my lord.
Okay.
My lord, page 45, it starts, my lord, page 82. This is report of the Second National Judicial Pay Commission, my lord.
No, no, where are the Jharkhand service rules?
My lord, Jharkhand service rule is, my lord, at page 31, my lord.
It happens is.
Eighty-two, if your lordship sees that, that is mentioned in report of Second National Judicial Pay Commission, my lord, Jharkhand. According to the information received from Registrar General in the state of Jharkhand, there is no specific rule in the judicial service rules dealing with retirement age and review at the age of 58 years. However, pursuant to letter dated so and so of the Honorable Chief Justice of India, evaluation of judicial officers on the basis of their past record of service, etc., is undertaken before they attain the age of 50, 55, and 58 years by the screening committee. And after approval of full court, the recommendation for retirement is sent to the state government. As per Rule 74B2 of the Jharkhand Service Code.
You come to page 38.
Yes, my lord.
Read rule 29.
Page 38, my lord.
Huh.
29. Conditions of service. All such matters relating to conditions of service of the officers of appointment under these rules and not specified herein shall be governed by general rules in this behalf.
So what is the age of retirement?
In state of Jharkhand, my lord, the age of retirement is 60 years, my lord. For medical professionals, my lord, it is 67 years. my lord.
Forget about what is the general age of retirement for the civilian officers? Civil
60,
officer,
60 years, my lord.
60.
Yes, my lord.
And what is the age of retirement of the judicial officers then?
60 years, my lord.
60 years.
Yes, my
So
lord.
then what is the,
My lord, I'm praying for the uniformity, my lord, because my lord, in
you are saying that there is no age of retirement.
my lord, I'm so sorry, my lord.
To be with the civil, the civil services, that if they have an age of retirement, say above 60, then you are also entitled to. You can't be denied. Otherwise, on what basis you want 61, 62? Why not 65?
My lord, this is very, my lord, because, my lord, we are praying for uniformity, my lord. In other states, my lord,
Uniformity with whom?
my lord, uniformity among the judicial officers, my lord. It create a homogeneous class, my lord, and there is.
You can only claim uniformity within the judicial officers of Jharkhand state.
I am praying there is no intelligible differential, my lord, in the judicial officers in Jharkhand or in, my lord, Telangana. Therefore, my lord, this issue needs to be considered, my lord.
Retirement of civilian officers in Telangana.
My lord, Telangana, it has been increased to 62 years, my lord. And for judicial officers, my lord, it is 61 years. Because if your lordship sees the order, my lord, of your lordship, page
If
183.
the judicial officer of Telangana comes to us saying
Yes, my lord.
that a class 1 officer in the state civil services is entitled to continue till 62, whereas I am being retired at 61, he will be justified to claim 62.
My lord, I am just praying, my lord, because of that uniformity in service, my lord. This first aspect, my lord. Second aspect is about the.
Uniformity is ideally it should be, but the uniformity can't be claimed like this that you before retirement you rush to a court and file a writ petition for your continuation.
My lord, and second aspect, my lord, and second aspect is, my lord, about the re-employment also, my lord, because 17 states have, my lord, introduced the policy to re-employ these judicial officers, my lord.
For re-employment, go and approach your High Court.
My lord, because this issue, my lord, pertaining to, my lord, the judicial services, my lord, as per all India judges, my lord, this window to approach before this honorable court.
You are not approaching, you are approaching us on judicial side. It's not that you for the improvement.
Milord, I have, Milord, the page 206, Milord. The association is defunct in Jharkhand, Milord. I have given representation, Milord.
Yes.
Page 206, if my lord sees. And I have mentioned, Milord, that I am to submit before good self that the matter enhancing the retirement of a judicial officer has again movement across the country. Recent judgment WPC number that the Honorable Supreme clarified that there exists no impediment for the state for the state or the Honorable High Court to raise the retirement of judicial officer to 60 years or 51 years, provided the High Court concurs and the state amends the necessary service rules. Milord. Thereafter, Milord, pertaining to the High Court of Telangana was recently permitted by the Honorable Supreme Court ordered so and so to increase the retirement age of judicial officers in line with Telangana public so and so. And thereafter, Milord, in Madhya Pradesh also, Milord, Maharashtra also, Gujarat has taken positive steps to enhance the superannuation of the age of judicial
They have
officers.
because the state governments or the high courts have done it.
This requires your lordship's consideration, Milord, with folded hand I would
Not
submit.
the way you want. That's the problem. That the petitioner is a principal district and session judge in the state of Jharkhand. The members of the the service conditions of members of the superior judicial service, like him, are governed under the Jharkhand Superior Judicial Service in bracket recruitment, appointment and conditions of service bracket close rules 2001 which have been notified in exercise of powers conferred by Articles 233 read with 309 of the Constitution of India. Under these rules, no age of superannuation as such has been prescribed, but Rule 29 of Chapter Roman Capital 3, which defines inverted commas conditions of service, inverted commas close, provides that all such matters relating to conditions of service of the officers appointed under these rules and not specified herein shall be governed by the general rules in this behalf. Inverted commas close. It is not in dispute that the age of retirement of the state civil officers in the state of in Jharkhand is 60 years. By virtue of Rule 29, the age of retirement from supervision of members of the Superior Judicial Services thus will also be treated, thus will also be taken as 60 years. The direction sought by the petitioner for enhancement of age of retirement to 61 or 62 years essentially requires a policy decision and consequential amendment in the service rules. In some of the states, the age of retirement of judicial officers has been enhanced to 61 years, primarily on account of the fact that the age of retirement of the officers in the government departments is also 61 years. 2 years.
62 years. 62 years, my lord.
2 years. That's what I know. There can be no doubt that a holistic view from a holistic view on the issue, on this issue is required to be taken by all the stakeholders, primarily to ensure that conditions of service of the judicial officers in all the states are broadly at par. Conditions of service, especially the age of recruitment or retirement, are broadly at par. Also, it, however, it may however not be prudent to deal with, to resolve this issue through a judicial dictate for the purpose of granting benefit to an individual officer. We are thus not inclined to entertain this prediction. The petition is however granted
May I
liberty
say only one thing?
to represent to the Honorable Chief Justice of the High Court, who in turn is requested to gather information from the other states, and if it is found that there is some disparity in the matter of prescription of the age of superannuation, let the matter be taken up on administrative side, the state government and other authority for appropriate resolution of the issue. The second prayer of the petitioner regarding re-employment and consequential continuation in service. I am aware of the view that such a decision has also to be taken by the High Court, by Honorable Chief Justice of the High Court in consultation with his judges of the High Court. Let the competent authority therefore take a final call in this regard, with force of observation and liberty to the petition disposed of.
I'm so sorry, my lord, for interrupting, my lord. I just wanted to say, my lord, that I have been told that some IE have been filing All India Judges Association case also for, my lord, for the same set first.
That will deal with IE.
So obliged.
My lords. My lords, item 5 concerns the felling of 4,000 fully mature trees. I would take my lords straight away to the photograph because a photo really speaks 1,000 words. If my lords would come to page 180 of the paper book. This is the vintage of the trees sought to be cut.
For construction of helipad in this kind of areas where lack of accessibility is there, if any emergency happens, if you have to pick up a person who is in
My lords, they've not explored any alternate sites and there are absolutely no permissions on record for the tree cutting. And may I just say, my lords,
conception we have in mind that they don't explore the alternate site.
my lord, the other thing, my lords, is that there are absolutely no permissions and the notification relied on, my lords. In fact, I pulled out because it's not on the file. If I can hand it up to my lords, that notification is not meant to be used for a carte blanche cutting of trees with absolutely no permissions. May I just hand up the notification? It was before the NGT, but it wasn't put on record. And my lords, in fact, what is happening is in the town planning scheme, they are planning to increase 1% tree cover in Ahmedabad because the city is facing the same problems as every other city in India today. My lords,
Plant in your side, what you want, it is all
they're increasing on the one hand and cutting down a ready-made forest, my lords.
plant is in different parts of the country. This tree does not require any plantation. It has a wild growth. And
May I
it's
show,
not,
my lords, the notification that is relied on? Because my lord, that makes it clear. What the NGT says is there are no permissions required at all under so and so notification. So my lord, the notification wasn't here, pulled it out. My lord, the notification in fact says
No, it says
if
municipal permission because they are non-forest area. So the Saurashtra Tree Felling Act says municipal authority
What
requires
literally you
to
would
give
need
the permission. But
yes.
these are sort of
it is
trees.
exempt, but my lords, please look at the notification. Just 2 seconds. I've handed it up, my lords. The notification, in fact,
Very good tree.
lists out a large number of trees. It's not merely this tree. There are 86 trees in this notification, and it is only when it is used for farmer purposes. The notification applies to farmers, my lords. So with absolutely no permissions, my lords, and the airport is right there, my lords. So it's not as though there's no helipad available. The airport is next door. This is a forest planted 50, 60 years ago. They're huge trees today. And even if you plant 100 trees in place of one tree, the oxygen content is not the same, my lords. My lords are aware of the. There's also flora and fauna, sorry. My lord, this property has nilgai, it has all sorts of birds. There's really a large ecosystem which has evolved. It may not.
why is it very simple? There are, this kind of plant, which is a wild growth, and that can, it doesn't require much labor even for, nothing is required to be done. These are all very natural.
That's a forest, my lords. That's a standard forest is like that.
No, a forest or no forest, it can grow anywhere.
Yes, my lords.
It's a plant which in adverse weather, it doesn't require water.
Hardy tree,
It
precisely.
it doesn't require, it's a wild kicker as they call it.
Yes.
It doesn't require any,
But my lords, we'll look at the notification. The notification does not go on that basis. The notification exempts are 86 trees for farming purposes. That's important, my lords, because they are giving a carte blanche with no. And my lord, this was in fact a suo motu petition by the NGT.
any case, the expert committee has taken care of it. They have said that in lieu of it, double of the trees are to be planted.
My lords are aware, my lords, one old tree can never be even 100 saplings. It'll take 50 years to get to
No,
the same.
this happens at so many
Yes,
places. We have
that's my
seen,
lords. I
there
agree.
is a very good alternate plantation throughout the country. If you have seen, there are very successful stories.
There are,
Particularly in Rajasthan, they
absolutely.
have done a lot of
I
planting.
agree, the desert
So
areas.
it is not that they will not do it. The only thing that somebody need to monitor it. That's all.
But my lords, in this particular instance, they've really not explored any alternate side. There's nothing, my lords, on record to show that they've done anything. They've not even got permissions, my lords.
We can only,
Basic permissions at least are required to fell a tree. How do you fell a tree with absolutely no permission based on a notification which is meant for farmers? And this is the forest department saying. No, that is the difficulty in this case. The case really is that is.
it was permitted, and of course, at that time, it was probably for some residential project. But instead of that, if you see page 320, the report,
My lord, sorry. Page
page 320,
320.
the conclusion of the expert committee report.
In fact, my lords, that expert committee report, we have challenged in a number of ways before the NGT because it only says there's this tree. We have shown that there are multiple other trees. There's flora, there's fauna. It's not merely this tree. So my lords are talking about that, at 320, my lords, I've seen that we have challenged. We've gone before, and this is not, my lords, my petition. This was a suo motu petition on my letter. I'm an environmentalist. I'm an 87-year-old.
No, you have a nearby,
that I want to preserve some.
you have a house nearby, that's all you.
I do, my lords, but that doesn't mean I don't want to save the forest. I'm trying to save this
No,
natural.
no, but see.
Ahmedabad, my lords, is called
we
the
are not-
lungs of
We are
Ahmedabad
not
also.
saying anything. You see, you can have, this petitioner can have some personal interest in the matter. But this expert body, see, the directions one, and this need to be only complied with, that's all.
My lords, they only do one visit, my lords. In that one visit, we in fact put all sorts of documents before them. They don't even reproduce what we've said. That is the one-sided nature of this committee report.
they
We put
don't
all
com-
that before the
If
NG.
they don't comply with these directions, then you must approach.
My
the
lords,
court.
but
We can,
tomorrow, my lords, if they see, one of the things that they also say, my lords, is that the larger trees are not being cut. That is put by the authorities. But then we show that the larger trees are being cut. So, my lords, all of this, my lords, but please, at least, my lords, hear the matter on this, because this is a matter, my lords, where
when you construct a helipad for the purpose of accessibility to a remote area,
the airport is right there, my lords. It's not as though there's no accessibility. It is next to the airport. The Hassel is the airport, my lords. I can say this with authority. I've been there a number of times. The airport is 5 minutes away from this area. So to say, my lords, that it requires accessibility, the accessibility is right there. And this is for the mines and industry department. It's not as though, my lords, this is being used for ambulances or something, my lords. And in that event, the airport is in fact there. It's next door, my lords.
there is no such finding, unfortunately, and
No, my lord, the fact that the airport is there, my lord, I can visit. It should be on the record as well, but I hadn't really marked it. This I know from personal knowledge, but I'm sure it'll be on the record if my lords would.
no, even if it is there, the helipad is something, a different kind of facility.
Yes, my lord, but to cut down an old forest like this with no permission, my lord, again, I'm going on the.
No, unfortunately, finding is that it is not a forest area. There are so many other findings against it. It is not a notified forest area, number one.
My lords,
Number
the Supreme Court has said a forest in
Plants which are
dictionary.
permitted are not a part of, virtually a part of any forest. These are wild growth, and it happens. Third, in any case, they have ensured that double of it, that wherever these are required to be
My lords,
removed.
on that, my lords, if the photos in fact disclose this, if I could also
Why
show you
don't
the
you
map.
suggest a site where the double of the plantation can be made?
My lord, that will still not serve the purpose of preserving these old trees, my lords.
Then should-
The real intention is only this gentleman's 87 years old. He's not going to gain anything by. And my lords, in fact, if you look at the airport police station, page 387, the police station complaint was the airport police station. My lord, that shows that it is the airport. It's right next to the airport. This area is in fact. My lord, I wouldn't push this hard, but in instances like this, you have a ready-made forest. You are trying under the town planning scheme to increase forest cover in Ahmedabad. And instead of finding a site where it's a vacant lot, there are bound to be sites, at least explore that, my lord, it's not even been explored.
That part, that apprehension we will take care. We'll say the incident appeal is directed against the judgment dated 3rd December 2025, passed by the National Green Tribunal as Western Zone Bench in bracket Pune, whereby individual application seeking prohibition of felling of Gando bowel trees for construction of helipad on inverted comma non-forest land has been dismissed after holding that it does not require any prior permission and also does not warrant any environmental intervention. Next paragraph. The petitioner's case appears to be that the subject area where helipad is being constructed is flood prone
Flora and fauna as well, my lord.
and the planted trees protect the area from submergence of erosion. The area is claimed to be part of the Sabarmati River floodplain ecosystem Next paragraph. In the backdrop of these allegations, which were contained in a letter sent by the appellant to the chairperson of the NGT, suo motu cognizance of the matter was taken, and a joint committee was constituted on 6 September 2022 to inspect the site and submit a report. The committee comprising of experts found that one, the trees were on the land not which was not included in any reserved forest category. 2, the trees were Kandu Bawal, which are ordinarily a wild growth. 3, if the trees are to be cut, twice the number of such trees shall have to be replanted. 4, the project was on government land and not part of the Sabarmati river front development boundary. 5, SEIAA, you have Environmental Clearance Authority, had cleared the riverfront project design. Next paragraph. On the strength of the report of the expert committee, the tribunal, by the impugned judgment, has held that 1, the subject land is not an ecological sensitive area, and as such it does not require any is not an ecologically sensitive area, as no such sort of notification has ever been issued by the competent authority.
My lords, sorry,
Why?
they're not an ecological sensitive zone. They're actually taking the technical definition,
The
not that it's
plants
not
is
ecologically sensitive.
Gandu Bawal on the survey land is a variety of tree which does not require prior permission for felling on non-pressed land. This conclusion was supported by a government notification dated 20th October 2015 issued by the Forest and Environment Department of the Government of Gujarat.
My lord, this notification is 2015. It's 2010, 2015, and it relates to farmers. That's what I was showing, my lords. This is the notification. In fact, they've not cited it in full. They've just extract. This is the notification, my lords.
Next paragraph. The
My lords will see list A. So,
agreed appellant has approached this court. We have heard learned counsel for the appellant at a considerable length and please the record. Next paragraph. It seems that the appellant's house is located near the site in dispute. In view of the fact that the subject land has not been notified as ecologically sensitive area, and this also does not fall within the definition of forest land, we are satisfied that the expert committee, in its conclusive remarks, has effectively addressed the cause flagged by the appellant his representation to the NGT. It would thus be appropriate at this stage to reproduce the following inclusive remarks of the expert committee, page 320. Next paragraph. What is thus required to be done by a genuine, by the appellant or some other genuine environmentalist is to ensure that the double trees which are being cut to develop the helipad are planted at a suitable area. On some suitable piece of land. So for this purpose, the appellant will be well advised to move an application before the NGT, who in turn may constitute a committee of experts, particularly from Forest Department, to select the variety of trees, identify the land and see whether the condition of the land is suitable for such plantation. The NGT can ensure that adequate funds for the purpose of selection of the trees and their subsequent supervision are allocated, or such an exercise is undertaken by the Forest Department of the state government. The NGT, through its supervisory committee, can ensure that the trees have actually been planted. Thereafter, at least for a period of 5 years, the periodical reports regarding the mortality rate, if any, or the appropriate growth of the trees would also be ideally observed, stroke monitored.
My lords, just one, I've understood what's fallen from my lords. Just one, my lords, request. Would my lord consider just asking the NGT to explore an alternate site if there isn't, my lord's order may follow? Just to explore that, my lords, because my lords, the
NGT is not
fauna
the
also,
expert for
I failed to
construction
point
of-
out. There are nilgai there, there are birds which are
NGT will explore the land for plantation of.
Schedule 1 species come to this forest. That's part of the reason that it deserves. My lords, if my lords may just ask the NGT to explore that.
And-
Let the forest department see if there's anything.
Well, please appreciate NGT is not the expert to.
No, correct, my lords, but they may ask the government bodies because under their aegis, they may
It's
actually,
become very dangerous to give them this power.
my lords can give any power, my lords, wishes to my lord, because in this particular case, my lords, there are schedule 1 species of animals and birds coming to this area because of this forest which was planted 60 years ago. So, my lords, I know what's fallen from my lords, but my lords just express.
Especially that development and environment both.
Yes, my
Both
lords,
goes together hand in
which is
hand.
why I'm saying an alternate, my lords. I'm not saying don't.
That's why we have
Have
put so many
precisely.
conditions, including allocation of funds, Forest Department, supervisory for next 5 years.
I know, I've seen that, my lords. My lords.
Lords, in this matter, I am appearing for the petitioner, my lord. My lord, the issue involved here,
Then you don't file this kind of petition. You should not file this kind of petition, Mr. Jahan.
issue is pertaining to the entry in the MPL. And my lords, if lordships may kindly appreciate page 2 of the impugned order.
In the presence of Mahakal, nobody is VIP.
But High Court records that the collector will give entry only.
Because you are unnecessarily, if you file a petition, High Court is bound to write some line here and
My
there.
lords, we made an RTI inquiry. In the RTI also, as well as in the minutes, they say that only the VIPs as at present will be given entry to the Garbhagriha.
The person, this kind of persons who file these petitions, they are not Shraddhalu. They don't go there. That's why we don't want to comment further. These people go for different purposes.
Actually, when, sir, before taking up this matter, mostly I was concerned with an equal treatment of entering into the Garbhagriha. That's the real issue. That if there is a violation of Article 14, that's the issue, my lords, which I am highlighting before this honorable court. My lords, my respectful submission is subject to correction by this honorable court. That so far as entry into Garbhagriha is concerned, there should be a uniform policy. Whether a person is allowed entry in the Garbhagriha or not allowed, it should be on the basis of a particular guideline or on the basis of a uniform policy.
Whether it should be or not be is not something the court should decide. That is the point. We are only talking of justiciability of anything. Ideally, it may be, but for that, let those who are in the helm of affair, they should take a decision, not the courts. If the courts will start regulating who should be allowed to enter the temple, who should not be allowed to temple, when should it be allowed, it will not be too much for the courts also.
My lords, if the High Court is differentiating between the citizens on the ground of, I completely understand what is falling from this honorable court, but subject to correction, my lords, my respectful submission is that citizens cannot be discriminated or differentiated on the basis of VIPs. My lords, if a person is entering a Garbhagriha, it is on the basis of a recommendation of a collector or a devotee, my lords, who is also visiting Mahakal. He should also have the right to enter Garbhagriha and offer water to the deity, my lord.
If the people will enter there garlanded with Articles 14, 16, sometime 19, then 20, 21, then better they don't go.
Yes, ma'am. There should.
First you will say, now I have right to enter because so and so is entering, therefore I will enter there. Then you say, I have now right to chant the mantras here because I have right to speak. So all fundamental rights will be there only inside the sanctum sanctorum. We don't.
My only issue is, so far as discrimination is concerned, either there is a complete prohibition.
Go and tell the authority. They will do
We'll
it.
make a representative. I'll withdraw it, my lord, we'll make a representative.
Counsel for the petition seeks and permitted to withdraw this petition as he wants to give his suggestions, talk recommendations to the competent authority.
Lords, in item 7, Lordships, may I just indicate that in clear violations of the orders passed by this honorable court, what the authority has done is, Lordship may kindly have the order.
Shankaracharya to enter the temple.
No, my lord, he is not Shankaracharya. He is not Shankaracharya, and the state government planted the Shankaracharya with VIP protocol and state guest list. And he came, he fought with the Pujari, and Lordship may kindly see the order passed by this honorable court at page 22.
He's got an injunction from this court.
In his FI, I'm so sorry.
Man out there.
My lord, he is,
He has to have become a wrestler.
my lord, he is,
Thanks to
my lord, the petitioner Vidyadas Babaji, he is a Bala Brahmachari, he is a Pujari from Ramanandi Sampradaya.
no Balgashari must be. We are not concerned about that. But then after taking so much, I think he is overfed with prasad and ghee and all this.
No, my lord,
That's why he has become.
my lord,
All time he has become more a wrestler than.
my lord, Lordship, the way,
If he can assault even a sadhu sant,
no, my lord, he was
Shankaracharya
assaulted.
coming there in the temple.
My lords, it's the other way. He was being assaulted, and my lords, the FIR has been registered over him.
No,
And
the prerna is seeking from the temple there. In the temple, you become always a person will bow down there. You are completely you surrender to the deity whom you believe, and therefore you are there. And this man is fighting, punching there, and
My lords, he was being punched.
in the boxing ring.
Lordship may kindly see the FIR. The Lordship may kindly see the conspiracy which has been.
He was not court or even the High Court to prevent another person from offering prayers.
Lords, he did.
You snatch away the dharma
This is
dandam
a-
of this.
Lord, this is a conspiracy.
Pandey,
Lordship may kindly appreciate what has
But,
happened.
Govindanand Saraswati.
Just give me just some time to explain, my lords, what has happened. My lords, when this honorable court, my lords, first of all, my lords, just give me 5 minutes to explain the history. What happened, my lords? Suddenly in 2019, in complete violation of Karnataka Act 1997 under section 23, this temple was notified. We challenged the notification by way of a writ petition in the High Court. The moment we filed a writ petition in the High Court, I'll show, my lords, to the records. The state government started filing FIRs against us. There's an order passed by the Honorable High Court that no coercive steps should be taken against Vidyadas Babaji, and 14 February 2023 order is there that he should be allowed to perform his duties as a archak. Be that as it may, in violation of the orders passed by the High Court, the state government appointed their own pujari in
Counsel.
violation.
Temple is meant for devotees.
Yes, ma'am.
You cannot own the temple.
No, my lords.
You
Lordship,
cannot own the temple and you cannot impose certain conditions, the other devotees not to enter
the
inside.
petitioner has not done anything like that.
Then
May I just
this is
explain?
specific allegation here made.
Lords, this is a conspiracy which has been hatched against my client.
Statement of the Tahsildar is also taken.
Lordship, may kindly appreciate what happened when the temple was.
Well, you have your own version, no doubt about it. You have your own version about the incident. You are trying to say that deliberately the incidents are taking place or the fight is being, that scene is created so that on one or the other excuse you can be thrown from there.
So great.
That's only a question of fact. It's a disputed question of fact.
Fact, correct,
It is
Lord.
now in trial.
Now, Lordships may kindly, I am so grateful. Now, Lordships may kindly appreciate that in complete, Lordships may kindly have the order passed by this Honorable Court on 11th of August at page 22. Kindly see how the authorities are in direct breach of the orders passed by this Honorable Court.
Why the High Court is not deciding that?
Well, the High Court has reserved the judgment on 19th of November. After reserving the judgment, this thing has been done and it has been published in the entire social media and other platforms that Vidyadas Babaji has entered into a scuffle and he is not allowing devotees to enter there, which is completely erroneous, my lord. My lords, this temple, my lords, the deity he is worshipping and serving the deity, no dan, no dakshina is going to him from his own, my lords, efforts. 500, 600 stairs have been built by him.
Then we only know one thing. All these temples where this limited government intervention for the purpose of management has come, all the quality of the life of the pilgrims and those who are going there, it has really improved. There are now good facilities up from the donation which comes there. The government constituted committee, we are not saying that everybody must be kept, but most of them are spending that amount on the welfare of the visitor. There are now good places to stay, some good roads conditions, health conditions, some primary hospitals, all these basic amenities are being provided to them. What is the problem with the government want to constitute some board to run the affairs of the temple?
No difficulty is there. My lords, lordships may kindly appreciate. So far as lords, may I just give a background? There are two provisions under the Karnataka Act, section 23 and section 42. Now the takeover under the Karnataka Act 1997 can happen under section 42 on the ground of mismanagement. And under section 23 on the ground that if a temple was notified under the earlier 8 acts, which are subject matter under section 23, which is Hyderabad Firstly Act 1349. Be that as it may, the constitutional validity of Karnataka Act is under challenge before this Honorable Court, and my Lord Honorable Justice Narasimha's bench is hearing the matter. The next hearing is on 4th of February. But my Lords, my respectful submission was that in complete violation of section 23 of the Act, this temple was not notified under Hyderabad Firstly Act, and completely in erroneous of the provisions of the Act, the state government was not able to show that this temple is under the Hyderabad Firstly Act. They acquired this, they notified this temple. The moment you notified this temple, be that as it may, there was no order under the Act to appoint a pujari. But Lordships will see they appointed a pujari. In complete violations of the orders passed by this Honorable Court, where Lordships have mentioned that petitioners will be allowed to perform his duties as a archak and give a room. Lordship may kindly see the notice which has been annexed there for a moment. This is a complete conspiracy, my lords, which has happened. Page 32, Lordship may kindly see. Just see the notice, my lord.
That we are aware of those orders.
So, my lords, the allegation, how this order passed by this honorable court is being circumvented when the writ petition, we are agitating our rights in the writ petition. The matter has been reserved by the honorable High Court on 19th of November. Now today, I am not being able to perform my duties as an archak, and I have been patented as a muscleman that I am staying with the people and I am fighting with the Shankaracharya. My lords, this is, lordship will kindly see, this is a great important tactic to defeat the orders passed by this honorable court and to defy my image as a priest, my lord. My lord,
Let us wait what the High Court will decide, your problem will be solved. If the High Court restore your management and everything, matter ends.
lordship, but till the time my rights as a archak should not be curtailed, my lord. My lords, I am being performing puja from 110 years. Ramanandi Sampradaya is performing puja there. For a moment, lordship, may kindly see FIR at page 26. I'll just show one para. Just show one para. The complaint HN Param Puja, and this, and with greatest of respect to this honorable court, this person is not Shankaracharya. They are self-proclaimed Shankaracharya. Lordship, may kindly see. Sri Govinanda Swami Saraswati Swami Ji, Pampa Kshetra, submitted his computerized complaint. The fact of the complaint is that I am Sannyasi of Adi Shankara, a nationalist, a Karnataka state VIP, provided with official protocol security protection. So he was, my lords, asked by the state government, with greatest of respect, to come there. My lords, videos are there. My lords, that's a matter of fact, but I do not want to highlight. He went there, he started fighting, and my lords, this scuffle took place.
No, if a Shankaracharya wants to visit a temple, what is your perceived wrong in it?
My lords, we did not, my lords, my client has not restrained him. Every person is coming doing worship there, my lords. No restriction is there, no restraint is there. He is sitting inside Garbhagriha and worshipping Hanumanji Maharaj, my lord. And he is doing all the rituals. Because, my lords, the priest here, my lords, they only know how to perform the worship of Lord Hanuman. And from 110 years, my lords, he is doing so. And lordships have protected his rights as an archak. Today, what is happening is, lordship will kindly see how my lord's order is being interpreted. What the state government is saying.
Let us wait for the outcome of the decision. What is the written number?
Absolutely.
What is the writ petition number?
Writ petition number. 10544.
105. So we are informed that the main case, that is writ petition number 105, 748/2019, has already been finally heard by the High Court and judgment resolved on
19th of November.
19th November 2025. The instant contempt petition disposed of with liberty to the petitioner to approach the High Court through an appropriate application in the pending writ petition. As the High Court is better equipped to verify the allegations, cross allegations, if so required. We therefore do not express any opinion on merits of the contempt proceedings and leave it to the wisdom of the High Court to issue appropriate direction. Next paragraph. It, however, seems that most of the issues will stand resolved as soon as resolved by the High Court is pronounced. Yes. With liberty to approach the High Court, the instant petition disposed. In final application, we are giving some indications so that
Great.
The writ petition was dismissed, my lord, by relying on the decision of Amit Sinha, my lord. But in Amit Sinha, my lord, there is itself observation that the SETI Commission recommendation, lordship, I have quoted at page H, my lord. SETI Commission recommendation, which has been accepted by this honorable court in All India Judges Association case, my lord, which reflects that there should not be any minimum marks for the purpose of.
why it should not be?
Lordship, can you see page H, my lord?
Interview, a candidate gets 0 marks because the High Court judges who are interviewing, they are satisfied that he doesn't know anything. But only because in the written exam he has got so much higher marks, he should be selected.
written examination, he has cleared, my lord.
Yes.
More than 50% marks, my lord. But in the interview, my lord, what had happened, out of 200 marks, my lord, 40% marks was made minimum marks, my lord.
So
With,
for example, in the written exam, you are required to have 50% marks, right?
yes, your lord.
But a person who is so good in reading and then in the written exam, let us say he gets 80% marks. 80% marks. And in the interview he gets 0. So eventually, if he gets 0, his overall marking will be remain more than 50%. And therefore he should be selected.
Here the issue is, my lord, here the issue is that, so far the, my lord, the candidates who are belonging to reserve category, my lord, for that, they, my lord,
When the question of reserve or non-reserve, you can have the criteria can be of less marks. That will in any case be there. So in the written exam, if the general category candidate is required 50%, OBC and SC/ST candidate will be required 40% or so.
that was not the requirement, my lord. In the main examination, there was no requirement as such, my lord.
Yes.
For the purposes of interview only, my lord, they made this requirement of 40% mark. Otherwise, my lord,
This is absolutely
45% marks for written examination for all the candidates, whether it is general or belonging to reserve category, my lord.
No,
Can you see the, my lord, the hardship of the petitioner, my lord, he got only 2.67% marks less than, which is the minimum required, my lord. And he, in the written examination, he secured more than 45% marks, which was required. I have placed at annexure P12, my lord. Only in the interview, my lord, and if you ask me kindly for equity basis, he should be considered, my lord.
89 of these judgments. Both all India judges are
against you, and that is what the High Court have rightly followed.
Also only on equity basis, if he should be allowed to.
How can we enforce equity, sir, when the rule is against you, the law is against you? If we do it, we will be violating our own judgment in Avimit Sina. That we can't. And that judgment has its own rather routine this court as well. The Shetty Commission recommendations or all these aspects have been duly considered. Having heard on counsel for the petitioner, do not find any ground to interfere with the imperial judgment of the High Court. If it could go that it could December 25 the High Court. Yes, sir.
This is the petition for providing reservation in body for ST.
Similar matter.
But at that time, some legal or constitutional provisions and the argument has not been raised. Kindly listen us. Okay, this is the petition not for on behalf of the 4 people, but on behalf of the 40 crore people of this country, which are SC/ST. Because since 1961 till today,
Have you seen our order of 22nd January?
we have seen this is the we have seen the order. In this order, pair number 2, order 22 January 2026. Pair number 2, it is not a dispute that such a reservation can be provided only through an amendment in the statute. But problem is that there is no provision in the Advocates Act for providing reservation to the women advocates in the Advocates Act. But this honorable court has provided reservation 30% to the women advocates. But for the SC/ST category and for the able advocates category,
Sir, woman, that's why the word used not is reservation. Only women are representation. And women are, the women can be general category, the women can be reserve category, the women can be OBC, the women can be specially abled, anything. So please do not compare yourself with women.
till today in bar bodies, no male SC candidate has been elected, and there is 1961. How women can be elected? It means that 30% which has been provided by this honorable court has been provided, which we given only to the general categories.
They will not go. The women started fighting in our court for almost last 2 years. They were visionary enough to approach the court last 2 years. They are fighting, and eventually they have succeeded. If you don't find any legislative intervention, and if you find that needful has not been done, our suggestion will be you also come well in advance before the next time it happens, so that wherever the judicial intervention is required, we can do the needful.
But candidly should notice the BCI, because they have taken the different stand before this honorable court in respect of SC/ST category advocates reservation and in respect of the women's category reservation. My last submission is that this honorable court, where ordered, when the reservation provided, given to the women's, it
But
mentioned
then you are using the word reservation for women. We have not provided any reservation for the women.
Kindly see, the
Yes.
order of this honorable court dated, in that order, reservation has been also been mentioned.
Yes.
When at the time of passing the order of the reservation of women, but the reservation has also been mentioned.
You are coming to the court when the elections have already been announced, the schedules have been notified, election committees have been constituted. At that stage, you thought of that you will claim something as a privilege which has been extended to the women members of the bar. We are only indicating you. That's why we said that if they provide you, well and good. If they don't provide, for the next elections, at least you come in advance before us.
Sorry, this period not for the next, this period for the future election also.
Yes.
So my next submission is that kindly should notice Bar Council of India, that let them come to the, take a stand whether the SC/ST provision, by they are arguing that for the SC/ST candidate advocates reservation, statute amendment is required, but not for the women. My next submission is that Article 330 and 332 and 332A is most important, because this honorable court has also mentioned in its order where the reservation of women were given, that there is a constitutional provision and there are also constitutional provision regarding the representation to the women in the bar, in the Lok Sabha and Vidhan Sabha. But Lok Sabha and Vidhan Sabha reservation has been given, but for SC/ST candidate category peoples, Lok Sabha and Vidhan Sabha reservation has been given since 1950. But because if we see the constitutional provision,
When was that reservation given? When was that reservation?
to MP, MLA, SC/ST given
So
national
when was that reservation given, sir?
by the constitution itself.
But when was that reservation given? How many years back? How many decades back?
75 years back.
75 years back.
At least 70.
Only because at that time, from the very beginning, they introduced a provision. This act where you are the advocates claim themselves to be the leaders of the society. You claim yourself that your presence is felt everywhere. You are in parliament, you are in assemblies, you are in court, you
But
are
we are not
outside the
local,
court.
we are not
You are
in
in
the,
judicial branch, you are there everywhere.
But
And
we-
this
we are
act
not a
is there
body.
since 1961. You don't do anything. It is only the court suo moto started making some initiative for the women lawyers because some of the women lawyers came forward. And ultimately, we succeeded with the consent and with the consensus of the parties to provide them a representation. Now suddenly you become aware, you want everything on platter without having any struggle for it. You should have challenged this act well in advance.
because the consensus can be given by the bar candidate to us also. My
Yes.
submission is that candidate call is to notice the
What
Bar Council of
prevented
India.
you to come before this court since 1961? This act is there.
My one submission also, because till 1961 today there is no SC/ST community advocates elected in bar body. It sees their reservation is required.
Therefore, this make more the things worse and alarming. You should have come 10 years back, 20 years back, telling now that there is sufficient member of the community are available, please think of providing some reservation to us. We would have first requested the parliament to have a legislative intervention. Suppose, assuming that somebody is reluctant, then you could argue, if at all, that please, this is a case where some intervention under 142 will be required. All these issues can be examined at length, provided that someone comes on time, at a reasonable time, giving a kind of a well advanced notice to all everyone, every stakeholder to think of it. Today you want us to exercise a power which the parliament is supposed to exercise in a matter of election which has already started.
Whenever reservation is given, which has been given to the SC/ST communities in 1950, reservation to the women has not been provided
That is
to
why
the women.
we also crossed our brief and we crossed other our limitations when we passed this order of 22nd. We recorded their consent that yes, the matter has been taken up with the concerned stakeholders. We indicated to the stakeholders that please take up the matter.
In our cases also, Bar Council of India shall give concession. Kindly notice the Bar Council of India, let them come, because the constitutional ethos.
Thank you very much. Thank you.
The further election, not the election they are seeking, but the further election.
Please understand, that is why this order of 22nd January, that is the reason 22nd January order is there. After some time, now please, you don't want us to advise you, take the full advantage of that order, make a representation to all the stakeholders along with a copy of that order. That Supreme Court has requested you to look into this aspect of the matter. We are quite sure that stakeholders are conscious of this fact. They are also sensitive of the issue that a particular members of the community, they require adequate representation, right? We are quite confident that they themselves will take up it. But assuming that they don't take up, then probably you come to us, and then today we can't say what are we going to do. But once a citizen comes in despair and say that yes, I have not been heard by those who are supposed to expected to grant me something, we will see what is to be done. We will use our some.
My last submission is that your lordship please kindly listen us. The question is that when there is no statute amendment in regarding women, why the state amendment necessary for the SC
That's the whole problem that you are now comparing with women lawyers. Yes.
BCA may be called.
Malik BCI may be called.
BCA may be called for the this consensus on this point, Malik.
BCI can give consensus, then there is no
Petition
problem.
may also be considered as.
Why we have been capacitated in respect by the BCI?
We have had long
So kindly
Possibility that the BCI will come and will give the consent for the.
as well as some of the petitioners in person.
there was similar order can be passed in respect of other cases also.
In view of the, we are extending something more, you please take advantage of that. In view of the order dated 22nd January 2026, passed in an identical matter, that is repetition civil number 6/2026. The petitioners will be at liberty to approach the competent authority along with a copy of that order. So we are hopeful that the appropriate competent authority will consider and take an appropriate decision. We are hopeful that the representation shall be, as a committee, we are hopeful that the representation will draw adequate attention of the competent authority. Today we can't say more than that. Now go and represent here. Good evening.
Hello.
Item 10.
Yes, madam. Hello. 8.44 acres of land, Ram Sabha land, was given to a private party for establishing a degree college, madam. After 26 years, they have not done that. My lord, even the Gram Sabha has passed a resolution to return of the land, my lord. My lord, I am a member of the Gram Sabha.
But you see, by the time now you approach the High Court, they say that 2 decades. Huh? 2 decades. After 2 decades, but they say that now.
Hello?
Now the construction of the college has started.
No. Yeah, they are saying that they are unable to construct the college. They are admitting. It is, in fact, my lord.
It's 23, 24, they said that they cannot.
This is at Annexure P4, my lord, page 23. They are saying that they are unable to. Page 23, they are saying they were unable to get the donations from the members.
Panchayat, not the individual.
Gram Sabha.
Right on. Land measuring 8.44 acres belonging to Gram Sabha Singakala, district Khedi, in bracket UP, comprising plot number 933, was allotted, so given to Pandit Deen Dayal Upadhyay, Ken Growers Degree College Committee, Singahi, district Khedi, for the purpose of construction of a college. The apparent object was that if a college is established, the it will facilitate the children of the village and nearby area to pursue their higher education. That purpose has been severely defeated as no degree college has been constructed at the site for the last almost 25 years.
It's 25 में ग्राम सभा is open meeting of ग्राम सभा.
The Gram Sabha, in an open meeting held on 1st September 2025, is alleged to have resolved that the land be returned back, be returned so revested in the Gram Sabha, as no college could be constructed. From where this sugar mill has come, somebody else has a vulture's eye on this land.
What's the cooperative sugar mill?
Is also resident of village Singaha Kala. The applicant may be returned. So no decision on that resolution was. The resolution was, the resolution was forwarded to the state government functionaries. There is a communication that they are
They have not paid even the compensation.
the society to which the land was allotted is also said to have passed a resolution informing the district magistrate Lakhimpur Khedi that it was unable to construct the college for want of funds Also, the resolution reveals that one Sarju Cooperative Sugar Mill, Pelaria, was expected to generate funds through deductions from the sugarcane growers and transfer that amount to the society for construction of college. As the sugar mill also failed to undertake such exercise, the society is said to have resolved that the land may be reallotted to the Gram Panchayat. Next paragraph. The petitioner claims to be a resident of village Singaha Klan approached the High Court through a writ petition seeking direction for the return of the land to the Gram Panchayat. The writ petition has been dismissed primarily on the ground of delay and laches, as the allotment had taken place way back on 28 May 99, and the first representation was allegedly made by the petitioner on 1st December 2025 only. Next paragraph. The delay in filing of a petition has to be seen in the context of the nature of relief sought in such petition. Assuming the petitioner had sought a return of the land soon after 99, there was every likelihood of turning down the prayer on the ground that the prayer it being premature. Some reasonable time had to be given to the society for construction of college. The writ petition was filed at a stage where the society has already resolved not to construct the college for want of sufficient funds, and Gram Panchayat has resolved that the land be returned to it. Per se, the writ petition thus may not be suffering from the ailment of delay and laches. Next paragraph. However, the fact remains that the petitioner, after submitting her presentation on 1st December 2025, rushed to the court within 10 days through a writ petition on 11/12/2025. Next paragraph. In such circumstances, we deem it appropriate to dispose of this writ petition, that is specially petition, without expressing any opinion on the merits of the claims, with the following directions. 1I, the state of Uttar Pradesh, through its principal secretary, Department of ग्राम पंचायत वेलफेयर चेक कर लेना क्या डेजिग्नेशन क्या होगा पंचायत वेलफेयर होगा वेलफेयर is directed to hold a fact-finding inquiry through the collector Lakhimpur Kheri. The collector will ascertain 1I, whether the sugar mill was obligated to deduct some amount from the sugarcane growers. 2I, if so, whether such deduction was ever made. 3I, if deduction was made, whether that amount was ever transferred to the society, college society. If not, how and where that amount has gone. 2I, the answer to the questions formulated here and above would necessarily might require further probe as to whether there is any remiss on the part of the sugar mill or not. Next.
Was then also a challenge to the allotment to the sugar mill.
Further examines whether the sugar mill had paid the value of the land to the society or to the Gram Panchayat, and whether possession of the land was also handed over to it or not. This question would necessarily determine whether the land legally, whether the land still rests in Gram Panchayat or in the college society, or it already stands transferred to the cooperative sugar mill. Next paragraph. The state government shall, based upon the inquiry, take a final decision whether as to why the land be not returned to the Gram Panchayat for its utilization for the purpose of common purposes of the village, if no price value has been received from the sugar mill, or if the college society is unable to construct the college despite more than 25 years have passed after the allotment. Next paragraph. In other words, the intervention of the state government is required to examine and take an appropriate decision in respect of a public property which seemingly carries, which is seemingly of high value, keeping which seemingly has a reasonably good market value. This public property cannot be allowed to be wasted only because of the uncertainties caused by the circumstances and the events that have taken place in the past. Next paragraph. Since we have not heard any of the parties, since we have not heard the sugar mill or the college society, it is clarified that no observation made in above shall be construed to have affected their right. All that we have said is the government must intervene and take an appropriate decision with respect to a public property, with respect to a property which at one point of time was undoubtedly the Gram Panchayat land. Next paragraph. The needful shall be done within a period of 4.
I'm so brief.
Please, Manoj. So there's similar petitions pending here. This is dealing with the issue of the identification of the political backward classes for the purpose of the 243D.
That it is already pending.
It's pending. So, because we are here, we are not asking for interdicting the elections, etc. Your lordships have given directions, but the question of law needs to be settled, Manoj. We have multiple litigations which are happening in states across the
But
country.
they could become party to those very proceedings otherwise.
No, the petition is here, Manoj. Mangesh Sasane, which is the petition with similar prayers, is writ petition 471 of 25. the orders your lordships have passed, page 722 perhaps, my lords, volume 2, isn't that very petition, where the Bantia Commission's report, your lordship says, don't act on it right now, please carry out the elections. They've carried out the elections.
Minus that report we have said.
Yes, minus the report. Now, that report and other reports of other states, what they're doing right now is unfortunately this, my lord. Despite the Constitution Bench and Krishnamurti saying that the political backward classes for these purposes are very different from the socially educationally backward classes for Articles 15 and 16. It's a specific argument that the Solicitor General at that time, Mr. Subramaniam, had taken, and it was rejected, saying no, these are two different classes, they're not the same. What is happening, however, is in state after state, what they're doing is they're taking their existing state socially educationally backward classes list. They're taking that list, copy pasting and saying this list is politically backward. What is required was the commission is going to be a dedicated commission. Commission will then identify not from SEBCs but from the entire communities in that state who are the ones who are not represented.
It requires a virtually door-to-door survey and
Correct. To know what communities are there and then to look at in the panchayats, in the municipalities, in the legislature, who are the communities that are represented. So if you're not represented, no matter who, I'm giving just for sake of example, if in a particular state, for example, I'm just say taking Brahmins because they're not part of, suppose Brahmins are not represented in their municipals and in the panchayats and in the legislature at all, then they would be politically backward class because they're not represented. It's not about socially and educationally backward. They would not have any right to come into 15-16 into admissions and employment. But they would have a right here if perhaps in an example. Now, if you don't undertake that exercise which the Constitution Bench and then Vikas Gavli's 2 rounds have said you have to undertake, then where are we, Manoj? We're just having a lazy exercise where you take an SEBC list and say, these are the people. Because 243D and T both say, only in clause 6, subclause 6 of those two respective articles, say you can, if you want, give reservations for backward classes. Now, if you are going...
Your argument that even if you are economically and socially not backward.
Yes, not backward, yes.
Not backward.
Yes, yes.
Or say if you are economically and socially are forward.
Yes.
Let us say like
yes, yes.
You can still claim political backwardness.
I think that could be argued, Manoj, depending on where this...
No, it can't be.
I would... Krishnamurti...
Your argument, but grades of the two. I feel socially and economically backward.
Well, I overheard Manoj Justice Bagchi, but that Manoj is very specific in the context of 16, where it says that if you're not adequately represented.
Your argument is that in 16 it will not apply.
Correct. There's no question. In
But
16
in
is only socially educated.
it will.
Correct. In fact, that argument was taken by Mr. Subramanian. I can show you. Before the Constitution Bench, in Krishnamurti, he says,
It was not accepted.
It was not accepted.
Does not accept.
Not accepted. And that's,
Krishnamurti followed the same principles as Indraswamy, creamy layer.
that's
So
by exclusion. Correct.
they put in the creamy layer matrix
Correct.
as political representation.
Correct.
Now let us say if a socially backward
Yes.
community has ample political representation,
Correct.
not necessary.
They will not form that class.
That doesn't mean,
Yes.
and socially forward community, no. Reverse is not true.
No, so what the court says is this, Manoj. It says that, look, we can't use only those parameters, but the court does say, and I must say in fairness,
Today, sir.
one example, Manoj, is like the Parsi community. They're tiny in number. So eventually, if you don't find them represented in communities, there's no doubt socially, educationally, they're not backward at all. But if, for example, you were to see the representation in Bombay, I don't know, Manoj, I'm just giving an example because it came off the top of my head. You wouldn't find them there. This
That that sort of representation, if you recollect the constitution, we made provisions for the Anglo-Indian.
Anglo-Indians, which has come to an end now, which doesn't exist
That
anymore.
has been that's commented upon
Correct,
as impacting on fraternity.
correct.
So we have to examine that angle.
That is true. That is true. No, that way, even these reservations, my lords, initially the only reservation in the constitution
10 years.
was 10 years for Lok Sabha and legislature. There was no 15-16. There was no 15-16 reservation. It was only a right if a state wanted to give the reservation. But the only one, the assurance in the constitution was for political representation. And there it was only for SC/ST.
That today, after Indraswamy and Ashok Kumar,
Yes.
it has been recognized as a constitutionally approved principle of
Correct.
equality.
Correct, correct. There's no doubt about that. The only thing is, my lords, when you're exercising as a state the power of subclause 6 and then you're opening it up, then you open it up to the politically backward, not anybody else. Lordship may consider
Can we hear it along with the, any date in the main case?
23rd February.
23rd February. The issue notice returnable 23rd February. Tag with SLP civil number, tag with the lead case SLP number 19756/2021.
That's all right. I'm grateful.
May I please, Lordship. Lordship, there are 6 prayer by Lord. Regarding the reservation, SC/ST reservation by Lord, we have deleted that prayer by Lord. In that regard, we filed amendment application by Lord. Saturday, I filed amendment application. We have inserted new prayer by Lord, because pursuant to your Lordship's order passed on 22nd February by Lord today, we removed that regarding the reservation in the Bar Council election by Lord. In that regard, we filed amendment application. Since there was a holiday by Lord, that application was not.
Because the matter came before us day before.
My lord, your lordship passed order in that. We are not in that reservation. We are not on that, my lord. We are mainly concerned with. We are mainly
Imrani and Mr. Narendra Huda. There were 2 matters.
My lord, we are not on that reservation at present. We are, because since your lordship's passed order, we are not on that. We are mainly focusing on the criminal antecedent, my lord. Your lordship may kindly see the learned judge of the Deed and judge of the Honorable High Court Division Bench. Page 48, my lord, how the learned judge have very painfully observed regarding the Bar Council elections. For a moment, your lordship's page 88.
What is your issue, please? We are not here to examine individual claims like this. There will be no end.
Your lordship may kindly see.
We are not sitting here as election tribunal.
My lord, there are 18 cases pending against the person who contesting elections. 18 cases, 5 cases. The Bar Council, my lord, 2023 brought a notification, my lord, prohibiting a lawyer having a one criminal case prior to 9 months, my lord, contesting from the Bar Council election, my lord. Suddenly, my lord, in October 2025, my lord, they brought an amendment, my lord, to Rule 4. Fixing 2 cases, my lord. Fixing 2 cases. Very surprisingly, my lord, the December, my lord, your lordship's passed order for election and all. In December, bringing a clarification.
Tag with repetition number 32 of 2026. Post on so date. Tag with repetition 32 of 2026.
There's one thing here, my lords. This petition is really like a mirror image to the other matters what my lords are talking about. The other 2 matters, yes, want the rule itself to be struck down. Here, what these people are saying is, you make the rule, amend the rule by which even 1 case is sufficient. This is something totally different. I mean, suddenly people are cropping up at the end of the day when the election is going on for all kinds of prayers. Just see the repetition, the amplitude of the prayers which have been made. My lord, just have a look at it, my lords. Each one of them has been grappled with by my lords. And that other matter my lords are talking about is the reverse, where what they are saying is the rule itself has to go.
No, they have filed they must have filed a counter petition.
It looks like that, my lords. I mean, with great respect, at some stage.
They are your friends. Why you are opposing them?
2018, my lord.
I'm not too sure.
My lord, I will tell the
background. We want all of this here.
I will tell the background of this, my lord. My learned senior counsel says 2018 Justice.
In fact,
past order, my lord, criminal background advocates.
There's one other thing, my lord.
There are certain directions, my lord.
Mr. Mishra is also.
Respondent number 5.
You examine that rule.
Exactly, my lord. That's what I was telling him.
Respondent number 5.
Similar situation that rule has created.
Yes.
Respondent number 5 was the chairman of the Bar Council. His background, my lord, I want to tell before your lordships.
Because I think
he was trying to influence the judge, bribe judge, my lord, sitting judge. He was facing the disciplinary action. The Honorable High Court, my lord, suspended him from the chairmanship and passed order
Honorable Justice Ibrahim Khalifullah and M.M. Sundar has passed order. In that order, immediately he went to he was not a party at all before the High Court, my lord. He got a stay of that order. Subsequently, the tenure is over. He was withdrawn that petition, my lord, no, appeal.
We will hear you on that.
Then this also, my lord, this order also is challenged.
All right, give a copy to them.
There is no issue, no, your lordship may kindly issue notice, I will serve the copy.
Notice they already issued, they are already there.
The formal notice, I have to file a process, my lord.
We have discussed, my lord, they are in the process of looking at the rule itself and how further it can be tweaked.
We are finding that rule quite problematic.
There is no rule, judicial precedence is there, they are not following. To whom protect they for bringing all this amendment and clarification, notification, we don't know, my lord. That is what they are making worry.
We know that it's a free of cost field.
My lord, this is only happening in Tamil Nadu only, my lord, nowhere else. This is happening. I want to read out your lordships. The entire bar must know that painfully, how the painfully observed.
That's why, sir, we have asked for their comments also. We will hear you.
That's okay.
One
Some
matter,
date maybe your lordship.
We are giving a date, we have already fixed.
My lord.
Lord, one matter which was Lord mentioned in the first hour by Mr. Giri, the senior advocate. Lord, what I say, we will sit with Mr. Giri. He represents the bar also.
Resolve, Mr. Mishra.
We don't want these matters to be discussed here, but in the open court.
This is the right for platform, my lord, to discuss this.
Wait. Lord,
We never want the court to unnecessarily pass this.
that is why, Lord, what I say, we will sit with Mr. Giri.
We will pass in that, right on in that order. On course of hearing, Mr. Manan Mishra and senior advocate and chairman of the Bar Council of India has also entered appearance. We have impressed upon both sides to resolve the issue amicably, in conformity with the order passed by this court on so and so date, whereby elections were directed to be conducted for all the state bar councils as per the time schedule and through the election committee / supervisory committee constituted void that order.
Lord, that Rajasthan matter, actually Rajasthan, that was left by, Lord, this was not mentioned which one will be the highlight.
We thought if there is a left out state, somebody will file.
What I say, what we did, we simply forwarded a letter to the supervisory committee that this is the position, whatever order you want to pass, you please pass. That is the simple thing. We have not done anything.
Why are they?
We can't dare to
take a call. Only to say, so far as the day-to-day issues that might be arising for consideration, we apprised the committee, high-powered committee, whatever is the designation, high-powered
supervisory committee,
headed by Justice Sudhanshu Dulia, to take appropriate decisions at their own end. It may not be necessary for the parties or the committee to seek any further guidance from.
My lord.
We are trying, we may not feel that.
We have simply forwarded the letter received from State Bar Council to this supervisory committee. We have not done anything.
Get it resolved and then you can simply inform us that.
My lord. Obliged.
Item 13.
Please, Your Lordship. Order, the interim order was passed, my lord, in this case. But, my lord, the interim order, my lord, page 112.
That's right, but then go and, it's not, don't project yourself as an old woman. This is all brother and sister fight, ugly fight between the brother want to grab the property of the mother and the mother wants to house the daughter.
My only submission, my lord. One line submission, my lord. 12th of February is the date fixed for petition, my lord.
After 5 years, when suppose she succeeds in getting this apartment, the daughter is ousted. After 5 years, you will inquire from her fate. How the son will look after or how a daughter looks after the parents.
But my only
that stark difference, only she will arrive, but by that time it will be too late.
I bow, my lord. My only submission.
That's why she is saying, I am not interested in mediation. It is not she is not interested. Her son is speaking through her.
But my only submission.
And he appears to be over greedy.
Not one submission only. Not 12th of February is the date fixed for the hearing of civil writ petition. My lord may kindly direct the High Court to.
No, we will not direct anything. We don't
decide it either way, my lord. Decided either way, my lord.
In view of the fact that the matter is now coming before the High Court for hearing on
12th of February.
12th of February 2026, we are not inclined to entertain this special petition. The Commissioner may request the High Court to take up the matter for final disposal. And so, however, the High Court is absolutely right in observing that the mediation must be explored between the parties. The High Court, in this regard, may isolate the petitioner mother from her son for some time,
It's on.
allow her to think.
12th March.
12th March. Allow the mother to segregate the mother from the influence of her son some time and allow her to take an independent objective decision as to whether she would like to whether she would still prefer to oust her daughter completely from the family property. A senior mediator in this regard can help the parties in resolving the dispute amicably. With these observations, the special petition is filed.
However, one request, my lord, if my lords permit me. My lord, one request, if my lords permit me. My lord, however, my lord, on the next date, my lord, if mediation doesn't work out, my lord, it be disposed of. My lord.
No, we are not saying anything.
Lord, may kindly, my lord.
We link to the High Court.
I'm sorry, in this matter, I need a week's time. I just want to place all the documents for your lordship which were there before the High Court.
Only conducted case, Mr. Sima.
Kindly grant me 1 week's time.
Seek 1 week time. Please don't change it.
I'm not at liberty to file the document.
Yes, yes.
Deeply.
It is granted to place in for additional document.
High Court, your lordships are going to ask me the obvious question, why 32? Plus, the lordships are going to ask me the obvious question, why 32 minutes? But just see the plight of this officer. 20 officers have retired in the meanwhile. I'll tell you what, there's one anomalous situation here. In the usual course blocks, once the High Court takes the calls on the rules, it is not notified. Your lordship kindly see this.
You know very well how the rules are formulated.
I understand. Now it has been gazetted. It has been gazetted. I had asked for a copy because only a typed copy was present. Can I just pass on the gazetted copy? This is a case.
How can Chief Justice himself formulate the rule?
Because it is subject. So two things happen. Page 40, if your lordship sees minutes, the rules are actually notified and gazetted with immediate effect. Thereafter, he writes a letter. The Registrar General writes.
When these are notified, the rule will not become. Who question is under the constitutional scheme? Who is the competent first?
29.2, my lords. Your lordship kindly sees it's the Chief Justice who formulates the rules, except where it involves a question of expenditure. The concurrence of the governor shall be taken. There are
and the age of retirement, sir, is condition of service.
There is no doubt about it. 229, your lordships have said.
Shows there the concurrence of the state government.
It is not there. It is not there. See page 42, 43, the Registrar General writes to the state government.
Just take up the matter. The question pertains to.
Just give me a minute. It's 20 employees have retired post the
What can we do? What can we do?
At least see, because the entire purpose of this is frustrated. Your lordship says at least 3 judgments, one of them a constitution bench judgment. Your lordship says, unless and until there are compelling circumstances, what the Chief Justice say under 229(2) must go through. Can I just place reliance on that? Otherwise, because for a lot of us, the entire purpose of having an amendment in the rules is frustrated.
This so-called amendment was made in 24. Now we are in 26.
26.
We could approach the High Court. And meanwhile, Manipur High Court has seen, I think, 4 or 5 Chief Justices.
That's what do employees, kindly see the plight of the employees.
No. Employee, you are working in the establishment of the High Court. You could have at least request your Chief Justice.
Because there's a writ pending in the High Court. Nothing has happened for the past 1.5 years. The writ is pending since 2025.
Misconceived reputation. What can we do?
7 hearings. Well, let's just see. I can only appeal to your lordship. What's the point of having a rule amended, notified, put it in the gazette, and then not working it out for 2 years? With all due respect.
Now we don't want to comment that this kind of notification is without authority. If the Chief Justice is passing an order, taking administrative decision which is contrary to constitutional scheme.
So far as the Supreme Court is concerned, the President promulgates the rules. There is no question of the Supreme Court issuing the rules. In the High Court, the scheme is the other way around. The Chief Justice issued, kindly see 229(2) for a minute. But then your lordships have said it is the Chief Justice's prerogative. The lordships have said it is a seat of, in other words, the High Court's prerogative under Article 29(2). Question is, they can refuse concurrence only in exceptional circumstances. Because concurrence having been pending for 2 years, because your lordship consider at least taking some explanation from them.
Since the issue involved is pending consideration before the High Court, in petition civil number 79 of 2025, we request Honorable Chief Justice of the High Court of Manipur to take up that petition,
Can I just give the details?
to take up and decide that petition at the earliest.
Writ petitions 79 of 25. Writ petition 79 of 25. Civil.
Well, we will not say anything except that he will decide the petition.
Just giving the number, Milord. Writ petition 79. Just giving the number, Milord. Writ petition 79 of 25.
We have put it.
Sir.
Number we have mentioned.
Clause at page 89.
Yes.
At 89 of the additional law. 89 of SLP. 89 of SLP, I'm so sorry, not 89 of SLP. .4 of the SLP, not the additional document.
Yes.
The bidder, 4.4, the bidder or OEM should have sold at least 240,000 numbers of sewing machines to central state governments, CPSU, BSU, private, retail, any other institution in any one of the last financial years, that is 1920 to 23-24. I have admittedly sold more than 4 lakh, admittedly. No, not admitted. Not admitted. You can argue, don't say admitted. No, I'll show admittedly also. I'll show admittedly. I'm making a statement with responsibility. The person who is made eligible is using my sale for the purpose of being eligible. Usha, I supply to Usha. Usha is made eligible by virtue of my supply to Usha. Now, Lord, please see this requirement is further, Lord, they say what is to be done at page, Lord, number 2. And the difference in price is, Lord, several hundred crores. I'm not giving the exact, my bid is not, Lord, disclosed. I don't want to disclose that. But more than 200 to 300 crores, I can assure your lordships. Now, please see, Lord, the number 2, private retail institutional sales. Performance will be evaluated in the form of a CA certificate only as per Annexure 5. The required supporting documents shall be maintained by the bidder for verification at any stage. It must ensure that stock transferred will not be considered as quantity sold. The facilitator MOMSNE reserves the right to get the invoices verified given in a CA certificate from an independent CA firm. In case the certificate is found to be faulty, the bidder OEM will be blacklisted and the performance guarantee will be forfeited. Now, this exercise of verification is not done by them. Now, Lord, please see what do I give. Just see, Lord, clause 5.3 is part of the agreement that I had with Usha. That is, Lord, additional document, page 36.
36.
Page 36 of the additional document. Can I have a copy? I don't have. Copy. Physical copy. I just send you.
This is filed by Usha.
This is filed by Usha in the writ petition along with their counter affidavit. This agreement starts from, Lord, at page 29 of this additional document paper book. I have a 5-year contract with Usha to supply them sewing machines. I'm the largest manufacturer of sewing machines in India, Lord, largest. Admittedly, of course, the solicitor may even object to that, but I'm telling your lordship something on the basis of, Lord. Three. In this, what was Miladi additional document? Additional document.
Petitioner, yes, I'll go to.
Documents in support of these are placed. It's there.
These were all there before the High Court also.
Because CA himself had verified it and it's part of the CA certificate. A2607.
Actually, it is there in the SLP also, but that's not very clear, so I have placed it along with this additional document.
Verified by the CA. The GST paid invoices are placed along with the CA certificate. CA verifies it, and that is why he says that the following.
Would your lordship, in the meantime, while they are locating, my lord, this additional paper book, just have a look at the CA certificate, my lord. That your lordship will find in the main paper book at 317. Page 317, my lord, 317.
317 also means volume.
No, in the main paper book, my lord. Volume 3, I'm so sorry, volume 3. Volume 3, Lord, at page 317.
Starting in 317.
317?
317, Lord, is the CA certificate.
Yes, good.
We have verified all the audited financial statements, books of accounts, cost record, purchase order, work order, contract agreement, LOAs, bills of quantities, bill-wise details of payment received, confirmation, retail sales invoices containing individual sale details pertaining to the toolkits, tools, items in the retail customer, GST returns filed on the GST portal, and other relevant record of Gemini, name of the so and certify the following details for the financial year 22-23 as per RPF clause 4.4 of the instruction to bidders. And if your lordship will see, the number of sales that are being shown is, Lord, at page 318, 4,17,000, 2,40,000 was the requirement. So I'm way above, Lord. And this is manufacturing. This is not, Lord, manufacturing and sale.
But what about,
and this is,
what about 319?
319, Lord, is the details of the sale.
Yes, so what about the work experience certificate and the work order?
So I'm coming to that. There is, your lordships are right. I'll come to that clause straight away.
Where you are faulted.
No, so I'm faulted on a hyper. I'll show, Lord, your judgment of your lordships, where your lordships have taken the view.
Term of the contract, sir.
No, I'm not asking for, no, Lord. With great respect, Lord. I'm not asking for term of the contract. I'm saying, Lord, give me, Lord, just to complete, Lord, what I want to say, Lord.
LOA को देना चाहिए था.
The work experience certificate.
The work experience certificate
is the rival tenderer.
The rival tenderer is considered qualified on the basis of my supply to him. On a basically hyper technicality, I am non-suited, knowing fully well that I have supplied. So please appreciate two things, Lord. Lordship may have then state away this judgment before I proceed further, Lord, because my Lord Justice Joymala Bakshi has a very valid point. Just have a look at this judgment, Lord, which is your Lordship, Lord, 2025 SCC online, SC 2368. Because your Lordships have taken a view with regard to public tenders, how public tenders have to be interpreted, how the larger public, more than 300 crore, I'm not disclosing the amount, the differences between me and them is more than 300 crore. And you talk of Bharat, you talk of indigenous manufacturer promoting, and this fellow is actually going to import machines. The person who's been given this bid at a several from China is importing from China. Just have a look at this judgment, Lord, just the paragraph 10 of this. Just have a look at this paragraph 10, my Lord. And this is a well accepted proposition. This is the latest judgment. I want to show only the latest. My Lord, the Chief Justice, Paratin.
Copies, you give copies to the other side.
Give it to the other side. A public tender is not a private bargain. It is an instrument of governance, a mechanism through which state discharges its solemn duty as a trustee of public wealth. Its purpose is not merely procedural compliance, but maximization of public value through a process that is fair, transparent, and competitive. The obligation of the tendering authority is therefore twofold, namely to interpret its own terms with consistency and to ensure that such interpretation advances, not defeats, the object of the tender.
The court must intervene in a case of demonstrative misconstruction of a tender condition or irrationality which affects the public interest. When an interpretation of tender condition narrows competition and excludes the highest bidder on a ground unsupported by law, the decision-making process is vitiated. The interpretation of the terms of the tender must therefore serve the object and purpose of the tender, mainly to maximize revenue of the state when it deals with natural resource. Now, my Lord Justice Bakshi is putting that.
Reason was in para 15.
No, so
Para 15.
in this also, yes, please see that, Lord. The reasonable understanding of the term previous financial year must therefore be treated to mean the year immediately preceding. This is, my Lord, of the facts of this case. Your Lordship, may see my facts are, I'll show, my Lord, how this judgment will apply in my case. Please see, Lord, 125, the Annexure 5. Annexure 5, note 2 is what is going against me.
SLP volume.
Just see SLP, Lord, 125, Annexure 5 is extracted there. And the relevant is, Lord, at page 126, subclause 2.
Yes.
Note 2, we are concerned with note 2. For private institutional sales, copies of LOA / work experience certificate must be uploaded along with the bid, and the same shall be considered for evaluation. Now, what I have done, Lord, I have uploaded the LOA. LOA is, Lord, my agreement with them. Letters of award, and pursuant to that agreement, there are supplies made. Now, if your Lordship can see the supplementary paper book, Lord, where the supply certificate is there, and I have enclosed along with my bid, Lord, all the excise document, which show that these are all excise paid, and these are all supplies made where excise invoices are there and excise made. Just see, Lord, the annexure, Lord, along with the supplement. If your Lordships have, Lord, the additional document, Lord, at page 29.
Not annexed, it says not applicable, not available.
Well, page 319, not available, not available, not available. That.
No, now, Lord, please see note, then while your Lordships are on that note, just see clause 6 also. Clause 6.
Mr. Singh, in commercial matters, tender matters.
Lord, hundreds of crores.
Can we substantially?
No, I'm saying, Lord, ultimately,
tender term.
I don't want your Lordships to I'm only saying, Lord.
Contract equity does not operate.
No, admitted in the sense, Lord, that the proof of is that I have supplied or not is the proof. That is being proved by excise certificate, Lord.
You are absolutely
But
right.
if I'm having
what you are trying to do is prove the supply through other documents than what the tender.
Unimpeachable documents. Lord, unimpeachable documents. Not something, Lord, the CA, Lord, why do these?
Then Ramana Shetty will stand in the way.
Lord, there is no question of Ramana Shetty. But here there is a person, there is, Lord, a requirement of supplying the machine.
Was anyone without an LOA or work certificate was permitted to participate?
That's not the hyper-technical, Ramana. I'm not on that proposition at all. I'm on reasonableness, which your Lordship, the recent trend of your Lordships is that the tender has to be interpreted hundreds of crores. This person is, just see, Lord, at page 127.
Please read note 3. Please read clause 3. Clause 3.
Just see clause 3 and clause 6 of, Lord, the same note which is going against me. Just see clause 3 and clause 6.
That's at page 89 itself.
Page 126.
Work has been allotted to whom?
To somebody who's buying from China and who's gaining by more than several hundred crores.
I'm sorry, my Lord, since China he mentioned, L1 is Kendriya Bhandar. My Lord, it's a government.
Kendriya Bhandar, which is
central government employees. Only a minute, sir. Employees Consumer Cooperative Society. L2.
Last so many minutes I'm looking for. This must be this National Cooperative Consumer Federation.
That is L2. The system is L2 is given an option. If he matches L1, he can supply 30%. So there is no monopolizing. So L2, who is supplying 30%, is not NCCF,
we are disqualified, and that is
Consumer Federation. L1 is Kendriya Bhandar. And my Lord, out of 4 lakhs which is to be procured, approximately 2 lakhs have already been distributed to the beneficiaries, the sewing machines.
Just see the arbitrariness, Lord. Usha is getting 3 lakh supply because of my supply to Usha, who is not willing to give me a certificate which I can use. It's Lord, this is a classic case where there are rival bidders for the same supply. There is only one manufacturing. It has been sold once by me, second time by Usha, by putting their Usha brand. That's why I want to show their agreement with Usha. Usha has sold my machines and is considered to be an eligible bidder because of this hyper.
Usha, the substantial part of the contract has gone to this cooperative employees federation.
So that is number one. Lord is not a manufacturer. Let me explain.
No, they were not manufacturer, but I think whatever way they will procure, it will generate some, you see, instead of resting the contract, the profits or the proceeds in one hand, it will be a kind of a cooperative distribution.
It is
Lord, if your
GEM
lordship,
portal, IT GEM portal.
if your lordships are Lord looking at that,
Not given to L1 as a whole. Our point is our bid is not considered because we are technically disqualified.
Lord, if your lordships are looking at that, Lord, public interest, then the bigger public interest is that hundreds of crores is being saved in this supply and an indigenous manufacturer is being incurred. Just see, Lord, just have a look at page 126, Lord, 126. 126, Lord, clause 2, your lordships, I read clause 2. Just see clause 3 and clause 6
SLP.
of the SLP paper book. All the records, lordships have that?
Yes,
All the records, audited financial statements, books of accounts, cost record, purchase orders, work orders, contract agreement, LOA, bill of quantities, bill-wise details of payment received, confirmation, retail sales invoices containing individual sale details pertaining to toolkit so-and-so of the retail customer, GST returns filed on the GST portal and other relevant record must be kept by the bidder to substantiate, verifying, backing up, corroborating aforementioned details, and the such shall be made available to the facilitator, supplied to them, MSME as and when required. Then PC 6.
It is on the basis.
That is with regard to the retail sales, not with regard to the institutional.
If your lordships,
Yes,
if I can
for retail
establish.
sales.
Third category.
Third category.
No, just see clause 6 also.
Yes.
Chartered accountant must match the details of the bills, including the invoice value from the GST return while issuing the above certificate, which is what the chartered accountant has done.
That's why please go back to page 89, sir. Please go back to 89. That's why
The requirement is only of having sold. The requirement is not lot of. And difference in prices in several hundred crores. Would your lordship not look at the larger public interest? And admittedly, according to me, I mean, Mr. Solicitor may not agree. Admittedly, I am meeting the threshold because I have GST portal. I have supplied these issuing machines.
By the government of India.
But I have 400 for more than 300-400
For the purpose of implementation of a social welfare scheme.
Ultimately, your and my money is going, Lord. Ultimately, consolidated fund of India is being used to pay some 300-400 crore extra.
Going from one pocket to another of the.
No, Lord, it's not going from one pocket to the other. No, with great respect, no. With great respect, Lord, Usha is the bidder who is getting 30% of the value.
This amount which loosely let us talk it as a profit or as a proceed of whatever. This will also be equally distributed in so many.
No, Lord, with great respect, no, Lord, if you buy something at a very higher price from outside, then most of the profit will go outside the country. Let me put it like, just see the agreement which I had also placed or which the Usha had placed.
There is no compulsion to buy it from the outside and to at a higher price.
No, I'm
Once there is a work allocated to them.
Once I'm non-suited on the ground of eligibility, Lord, then my price is not opened at all. If my price is not opened at all, Lord, then he becomes the L1 bidder by virtue of my price not being opened. I would like to put it in the very simplest of terms. The requirement in the tender is of having sold 2,40,000. That's all, not even manufactured and sold. I have manufactured and sold. More than I have sold 4 lakh. And my GST returns prove this fact. And for the purpose of confirming the sale, just have a look at page 36, 29 of the additional document, if your lordship have got that additional document. Page 29 of the additional document.
This is a one-time.
There are 8 lakh pieces to be supplied.
4 lakh.
they have this clause.
Usha, just for clarification, is not a Chinese, it's an Indian company. Usha is an Indian company. We have been seeing the sewing machines.
Usha is not a manufacturer.
Usha and my lord, the Singer. They are very well Indian.
Both are Indian product.
Yes, man.
Usha got it from us.
And page 217, 218, they kept the relevant part blank, which according to us, my lord, was the crux of the tender document. That was the main component of the tender document.
Usha is eligible by virtue of taking supply from me. Just have a look at that agreement, Lord, which is at page 29 of the additional document, page 29. This definitely will require examination is all that I am not requesting. Ultimately, Lord, this is only first appeal. Any matter which comes directly from the High Court. And it's a large public interest is involved, Lord. Large amount of public interest. Have it for disposal any day, Lord, we will satisfy your...
No, had it been going to some private entity, the...
But it's not, Lord, please take it, Lord, Usha is a private entity and it's got 30% of the
Half of the
supply.
contract is executed. The recipient, my lord, the beneficiaries have
There was
received
an
the
interim order
out
by
of
the High
4
Court
lakhs,
subject to.
out of 4 lakhs, of course, everything is subject to. Out of 4 lakhs, Lord, 1,79,000 sewing machines have received, are received by the
What has been
beneficiaries.
received, that loss has already happened to the public exchequer, but that doesn't mean, Lord, your Lordship will allow the public exchequer to be again, Lord. Just have a look at this agreement, Lord. How Usha became eligible. Just have a look at that, Lord. Page 29 of the additional document. How Usha became eligible. Just see that document, Lord. And Usha places this document on record. Page 29 of the additional document. This is an agreement between us and Usha.
Usha is a credible product, right from the...
But why, Lord, supplies from me? Usha is a brand name. Lord, please appreciate, Lord, the difference between Usha and Gemini. Usha is a brand name which has developed over a period of time. Supplies by me. Gemini is the supplier. I have supplied all the sewing machines to Usha. It is my machine which is being sold by Usha. And my payment will not be made by Usha unless they find I want to show that clause. Unless it specifically conforms to the standards of Usha. Just have a look at page 29. This is the agreement between me and Usha.
Clarify point, please.
And just see, Lord, they are only putting their label on my product. Just see page 31st, Lord, clause C. Basis the aforesaid representation by the supplier and subsequent discussions pursuant thereto, UIL intends to procure goods from the supplier. Then, Lord, next page. The supplier shall supply UIL all the goods detailed in so-and-so of this agreement on a non-exclusive basis as and when required by UIL. The description of good may be modified from time to time by UIL and suppliers agree to implement. Then, Lord, E, the UIL shall have the right to reject goods which are defective or not as per the agreed specifications. Then, Lord, this agreement is for 5 years and then straight away come, Lord, the term of agreement comes at page 32. This term of this agreement shall be 5 years, which shall commence on 1st June 2023, and this agreement shall expire by flux of time. And then 36.
Terminable at their instance. If they terminate it, they have to stop.
And just see 36, Lord. 36. 5.3. After receipt of a proper GST, complied invoice by UIL for satisfactory supply goods duly except by UIL, UIL shall release payment of undisputed amount as per the payment terms specified in Exhibit B of this agreement at UIL's option. If the last payment day as applicable falls on the weekend, so your Lordship will skip all that. Now, this is something where I have supplied to Usha and Usha has paid me in terms of
10,000.
3,10,000 is not paid by me. And which is,
Invoices are produced.
and 2,40,000 is the only requirement. And the requirement is of sold. It is not requirement of anything else. If I have sold, admittedly, and the government records, the GST portal exhibits that I have sold more than 2,40,000, Lord. Will a technical interpretation of this kind, Lord, not require examination at your Lordship's hand is the only thing that I can beseech your Lordships today.
Just answer.
I can understand, Lord, an order and supply has been made, but that doesn't mean that this supply should be perpetuated, Lord, to be done at such a high rate compared to, Lord, what rate I have quoted.
They don't give us a certificate because they are the right.
And Usha is refusing to give me a certificate. Where I'm, Lord, where is my tender being rejected? No, Usha doesn't, a rival tenderer refuses to give me a certificate which I am unable to place, because of which they become, Lord, eligible and I am not.
Therefore, I place the invoices and bank statements.
And that is why I place all the bank statements, all the invoices of payment received, and CA examines everything and CA certifies everything.
That's on page 319. Just go to 319 once.
You have been supplying, maybe that as per this document, you are supplying some components.
No, I'm sorry, my lord, full sewing machine. I am supplying, this agreement is not, what I am not claiming is not a supply of, that is not the ground load on which I am not suited. I am supplying fully complete assembled sewing machines, which is being used by Usha. It is not as if I am supplying some toolkits. The tender condition also blood says toolkit, so that's the word blood which is used, but it is actually a full-fledged sewing machine, and it's not blood that I'm not suited. Supposing blood, if the rejection had been saying that you have not supplied a full sewing machine, you have supplied only toolkits, I would have no case at all. I would not be standing before your lordship. Here I have supplied the sewing machine which is directly being sold by Usha after just putting their brand, which is Usha.
Not being supplied, therefore those columns are blank. That's what the High Court also said.
And just see, my lord, from 319 onwards, right up to, my lord, this goes up to 400 and something. 410 is each and individual, every supply lot backed by GST returns, backed by GST filing, and all verified from the GST portal. And the bank statement revealing that this supply has been made, payment has been received by me. I am only beseeching, Lord, if there is a public interest involved and your lordships have held not only this judgment, Lord, even earlier judgments.
Maybe next time you will become little wiser and you will.
No, Lord, it's not a question of me. I can't be wiser, Lord. I can't be wiser because if the competitor is also a bidder, Lord, and he refuses to give me a certificate because he is also a bidder, and he will be an eligible supplier for the purposes of, Lord, making a bid, and I will be non-suited in spite of my material being used by him to become eligible.
This will continue. But this is not something one time bid because this is only.
No, this will continue for 5 years, Lord. This is 8 lakh lot machines, and the difference I have said on oath is in several hundred crores. Just see that, Lord, I have said on oath that the difference is in
Another tender in future, not there. This is one time.
I have said, Lord, at page 28. I would only beseech, Lord, it's a first appeal, your lordship. Please give me a proper detailed hearing. Lord.
Division bench of the High Court disposed of the writ petition.
Because there is no interim order which can be passed. It's only, Lord, your lordship can examine this matter from a larger public interest perspective.
It will literally become academic. That's why we don't want to.
No, the supply against the 8 lakh order, only 4 lakh supply order has been placed, Lord. 4 lakh order is not placed at them as yet.
Examine some good case, maybe.
This is according to me the best case which is.
We have heard Lord Senior Counsel behalf of the petitions as well as learned solicitor on behalf of the Union of India and other Lord Senior Counsel representing the respondents. Having regard to the fact that during pendency of the proceeding before the High Court, a substantial part of the contract has been complied with, namely more than 1.79 lakh sewing machines have already been distributed to the beneficiaries. Coupled with the fact that the view taken by the High Court is one of the possible views, we are not inclined to interfere with the impugned judgment of the High Court. So, however, the issue of law raised by the petitioner is kept open and is kept open to be gone into an appropriate case.
Keep your blame.
Great.
Yes, item 42.
Yeah, please. The corrected matter, my lord, is page 119. Your lordships have issued notice.
Have you seen the condition in Gurgaon? Construction and material.
Page 119.
But this is an association, come on.
They are expert in encroachment.
No, my lord, these are allotted lands. These are not, my lord, these are allotted to them in 2004, 2005. possession certificate given.
In any case, Mr.
Lord, these are not encroachers in anyone. Not even a single person is encroacher.
I have dealt with this.
Lord, I have your lordship's order is at page 34, my lord.
Controversial matter in High Court with great difficulty. They got them rehabilitated, but they will never be satisfied in life. That is the problem. Because when you get everything on platter,
No.
the problem.
Lord,
You should welcome in your city. Metro is coming. The metro is being constructed.
difficulty is, my lord, none of them have been given, my lord, a public notice. You will be given alternative site temporarily. And they come and start demolishing their buildings, my lord.
For a metro, we will not distribute. In this country, metro should have been 100 years back. Because we are already 100 years behind.
My lord, may just kindly see, my lord, page 119, your lordships are seized of this very matter. Page 119.
They will call that and dismiss that also right now.
My lord, now just kindly see, my lord, the public notice they have given. Just kindly have page 63. 64.
Since the land of the petitioners is so to be utilized for the purpose of construction of a very prestigious project, namely construction of metro railway line in a congested place, city like Gurugram, we are not inclined to interfere with the taking or occupation for the land for that purpose. However, the taking over of land and its utilization for metro project development cannot in any manner cause prejudice to the right of the petitioners, members of the petitioner association, if any, to seek rehabilitation, stroke alternative site, or compensation for the.
My lord, may I only submit this? My lord, may I only submit this? Kindly have page 64 for a minute. Kindly have page 64 for a minute.
They want to blackmail.
My lord, I am not.
Give us thing and then only.
My lord, I am not at all. My lord, I'll just show page 64 and give a solution, my lord.
Yes.
Kindly have page 64 for a minute.
Yes.
Kindly have page 64 for a minute.
Please tell us what is there, 64.
My lord, page 64, they have given a public notice that they are shifting us temporarily to a nearby site. What I am submitting is, let them come and tell your lordship, they are shifting me where?
You are not Zugi dwellers, you are not persons who are dying in a day, you are selling marble to the people, you are made enough money out of this market, you will be entitled to. That's why we are saying you want to blackmail. First you give us the site.
My lord, I am not.
Then will declare the site is not suitable and the metro project will wait.
No, my lord, this is not me, my lord. Those are my rivals who have filed, my lord, the petition.
All such issues will be decided by the authorities at the earliest. In the event,
I could, there is a petition.
all the can be raised before the High Court in the pending writ petitions. We request the High Court to examine these aspects and take an appropriate decision.
My lord, may I only submit this, my lord, the solution which I was saying, page 64, they themselves are saying they are giving us temporarily an alternative site. What I am saying is...
We are not saying that you are not entitled to.
No, my lord, what I am submitting for your lordship's kind consideration is, let them come and give us, my lord, alternative site. I am ready to
go. Have seen in the past, if somebody will take the temporary site, the others will not vacate this site, the project will never come to.
My lord, all of us will give undertaking before your lordship. We will move out of this place.
We'll go and give to the High Court. Matter is pending in the High Court. Say, first of all, we have heard on civil counsel for the petitioner. In view of the fact that the matter is pending in the High Court, there is no reason to entertain the specially petition. However, the petitioner's claim regarding so and so. However, the project being so and so, no interference, and alternative will be considered by the High Court. For which we request the High Court to take up the matter on the date fixed.
My lord, in the meantime, they should not, my lord, demolish my buildings, my lord.
Let them demolish everything.
No, sir.
We have no. The metro is most important for the.
My lord, metro is not yet started, not even, my lord, the foundation.
Private right versus public interest, and public, you know very well.
My lord, I am myself saying, my lord, please give me an alternative site. I am ready to go. But my lord, without giving me any alternative side in this public notice,
Assuming there is no alternate side, you will be entitled to compensation as per the law.
my lord, where will we go? My lord, 22 years back we were uprooted, rehabilitated. Today, after 22 years, my lord, I am again being relocated to a temporary site, not known, my lord, how much the area I am given. Kindly the pay 64. Nothing has been stated what area, where, my lord. What I am saying is, please, my lord, call upon them. Let them show, my lord, your lordship, what alternative they are giving, we will go.
There are other poor people before us, we try to spare time for them.
My lord, these are also, my lord, rehabilitated people.
Standing in High Court, please go there. You don't have patience even to wait for the work will be the
But
outcome.
what do we do? They are demolishing, kindly see page 99.
Let them demolish. Item 43.
Female Sarpanch, my lords. She was elected as a member of the Gram Panchayat, my lords, in the year 2021.
Very time is over. Here
Your lordship,
you are admitting encroachment, you are seeking regularization.
she is a declared homeless, my lord. She is a declared homeless. Her
You are a
proposal,
Sarpanch.
lords, her proposal for
Please to interfere in the
proposal for the regularization is pending, lordships. During the pendency, my lord, she has been disqualified.
You are more interested in regularizing the encroached land instead of continuing as Sarpanch. So better you concentrate on that.
Your lordship, the term is only ending until 14th of February, my lords.
So you want both the things, cake and eat too.
Lords, but only after she was elected to the post of Sarpanch, my lord, this complaint has been filed, my lord. It is clearly covered by my lord's own judgment, my lord, in the Manisha Ram.
If you are ready to vacate the site within 2 days, then question will arise.
Yes, my lord, I am staying at that place, my lord, since last 40 to 45 years.
Then better continue to stay.
Lords, kindly consider, my lord, this is, my lord, the rival complainant has filed a complaint only after she was elected to the post of Sarpanch, my lord. Lord, kindly protect me until the mandate.
No question of protecting.
All right. Right, please.
At page 8, but the High Court notes that the final report has been filed, but limits, my lord, the anticipatory bail only to 15 days. So that is in the teeth of your lordship's, my lord, Constitution bench judgment in Sushila Agarwal. Kindly have a look at page 8 first, my lord. No reasons given, my lord, why it should be limited. Page 8.
You are again indulging in illegal mining.
I am not a minor. In fact, my lord,
You are not minor, you are major. We are that low. What kind of activities are you doing despite?
I have got a report. Please have a look at first page 8 and I'll satisfy your lordships on the facts. Kindly have a look at page 8, my
You
lord.
are found to be involved in illegal mining on government property despite the stay by the High Court taking suo moto. What kind of then anticipatory bail should be granted to you?
Lord, bail was granted. Please have a look at page 8, my lord.
We know that.
Bail was
I
granted.
could have granted even for 15 days.
Lord, now kindly see on the facts, my lord. I'll satisfy your lord.
How much loss have you caused?
Sorry, my lord.
How much loss has been caused?
No, my lords. In fact, my lord, what has happened here is that the inspection was conducted. The first round of inspection, my lord, found that there is no, my lords, this crusher. I am, my lords, only running a crusher. And, my lords, there is no illegal mining. Please have a look at, my lord, first.
Transported.
No, my lord, my role, even in the charge sheet, is limited only to transport. And, my lords, 2 allegations were raised against me. One about forgery.
All right. Issue notice. Returnable so-and-so date. Meanwhile, the interim anticipatory bail granted to the petitioner is further extended. So, however, Chief Secretary Uttarakhand is directed to Chief Secretary Uttarakhand and the Principal Secretary, Department of Mining, are directed to submit a tentative fact-finding report with respect to the loss already caused by the petitioner to the state revenue, as well as in terms of the illicit, the value of the
Transportation, illegal transportation and sale.
transported minerals, etc. Also, the condition of continuation of bail will depend upon the continuation of the anticipatory bail will depend upon the conditions which we propose to improve. List after 1 week. That- We are ready to transfer this amount.
Pardon, my lord.
Are you ready to transfer?
Kindly see page 86. He has already withdrawn the entire money. His own statement. Kindly see page 86. There is an error which has crept up in the order. My lord, he is taking advantage of that. It is not my money. It is lying in some company. That company has returned to SHO that we have defrozen his account. He is free to withdraw his money. Kindly see page 86 for a moment.
Oh, no, after the court order, where have you paid the amount?
Pardon, lord?
After the court order and your undertaking of 8 crore or so.
No, not 7. Kindly see, there is no such, my lord, undertaking that I will deposit 7.5 crore or any amount, X amount or Y amount. What I said, I will facilitate his account getting defreezed, which I did. Company wrote to SHO that we have defrozen. He is very well to withdraw his money. Kindly see page 86 now, my lords. He invests 4 crore. The account makes, my lord, about 10 crores. 7 crore 52 lakhs he has withdrawn. Kindly see the last column. 7.52 crore which has already withdrawn. My lord, and my lord, what remains is 1 crore 94 lakhs. Now kindly see page 92. What the High Court, my lord, commits a mistake is instead of 192, courts writes it as 7.2 crores. Page 1 of the impugned order. This error comes in. Court says you have undertaken to deposit 7.5 crore. I never said I undertook to deposit any money. All I said I will facilitate. My lord, this amount he has already withdrawn, but court, my lord, erroneously says that this amount has to be given to him. That is his own statement filed by him in the court. Lord, I file an application saying that it is not 7.5, it is 192 and the company has already defrozen. He can withdraw it any day. Now, because of this error, he says, I want 7.2 crore, my bail gets cancelled. Court says you undertook 7.4 million. Kindly see my bail order. There is no figure mentioned in that. All I said was I will facilitate his defreezing of the account because he doesn't supply KYC documents to the company. Company says give us these documents. There are money laundering issues these days, so supply all the documents. It doesn't do, but before that he has already withdrawn his money. This is his statement at page 86.
This account page 86 you are showing. This amount was withdrawn when?
These monies were not face by face, he has withdrawn. Before his defreezing.
He has withdrawn. That is what.
Before cancellation. He has already withdrawn.
No, the question is not of cancellation. The question is that what is the date when you undertook before the court?
Yes, 13/5. 13/5/25.
So sure that this amount is withdrawn after that.
No, Lord. What happens is this is an account maintained by him.
In the course of transaction, he has withdrawn.
So this is an account maintained by him. I have no access to his details of his account.
When you unnecessarily assure the court for withdrawal of the payment, before that, according to you, May 25, this amount had been withdrawn. Then why did you make this statement?
No, my lord, I made the statement that I'll facilitate defreezing. My lord, I have no clue how much money is lying in his account. That is personal to him. They have a login ID, they have a password. Nobody else can access that amount. Lord, I have no clue here whether it
Sir, in May 25, when you were being granted this privilege of bail, you say, I will allow him to facilitate the withdrawal.
Correct.
So you now cannot go back to a withdrawal prior to
company has returned to SHO, please withdraw the money. But the error that has crept is 7.5 instead of 192. The High Court says, my lord, you have not allowed him to withdraw 7.5. 7.5 is already withdrawn. What remains in his account is only 1.94, which is at page 86. This is a statement filed by him. I have no access to his account. I don't know whether it has 1 rupee or 500 crores. I only said I'll facilitate. I have facilitated that. I have complied with my undertaking before the court. Because of the error in the order, my lord, he is now trying to take advantage of that.
No, but that error also, when did you apply to correct that error?
No, immediately. Kindly see page 128. Immediately. And that was allowed also. That application was allowed by kindly see page 3. The court allows that. Straight away, my lord, I'll show that line. Page, my lord, 3 of the impugned order, the second impugned order. The very first line, my application is allowed. This is that application which I filed to say that it is not 7.5, it is 194. That application is at page 128, 130.
Let's wait there for the other, are you there?
For the state on advance notice, Manoj. I appeal for the state on advance notice. Manoj, me see the para 11 of the impugned order. The High Court duly observed that they are just turning away from the facts already pleaded and
No,
trying
that's
to
not-
argue the case.
What?
And in the
what
impugned
is-
order itself, they say
What is troubling us is only one thing, that how this recovery issue has become a matter of criminal proceedings. Bitcoin, this coin, cryptocurrency, he took away this much. These are all business transactions. Whatever fraud has committed, of course you can investigate. But why these conditions and preconditions are coming?
30 lakh M coin still in his account in page
Back
3.
his entire money. 2.5 times.
Consider, then accept notice on behalf of the state. Meanwhile, meanwhile operation of the impugned order of the High Court cancelling the bail is stayed. The petitioner shall continue on bail, subject to his furnishing a bank guarantee of ₹2 crores. Subject to, subject.
It's already withdrawing, my lord. Yes, my lord, company has written a letter to SHO that he can withdraw that money. All he has to do is to withdraw it. It is his account, my lord. I have no lien or access to his account. So where is, my lord, why should I deposit this 2 crore, my lord? I am also an investor like him.
You are not an investor, you are
No, I am an investor, my lord.
who has taken away this money.
I was already investing, my lord. I told him that this is the investment I have made on my, my lord. He also invests. He has made 10 people as accused. All are investors, different persons. Because his account was frozen, this complaint is triggered. And my lord, this 2 crore may not be said, my lord. As of now, my lord,
Unless you furnish a bank guarantee of 2 crore, we will not grant you bail. Your entire conduct
any
is
other condition.
completely fraudulent.
Lord, tomorrow I will facilitate, let him withdraw that money, my lord, 1.9 crore. Tomorrow itself, my lord, let him withdraw. That is the amount, my lord. SHO has, my lord, these mails have been given to the SHO by the company directly. He can withdraw his money, my lord, entire money. If he is not able, then, my lord, let him come back and, my lord, make allegation against me. Give me the email, my lord. Yes, so the company has written to the SHO, my lord. Lordship may say that, my lord, SHO may facilitate this withdrawal also. It is, my lord, the login ID, password are with him. Nobody else can access to that account.
The SHO, Police Station Cyber Crime Sangru, will facilitate the complainant Ashok Kumar.
Ashok Kumar is the complaint.
Complainant Ashok Kumar for withdrawal of 1.94
Yes.
1.94 crore
Yes, my lord, that is at page 86. My lord, that is the statement filed by him.
from the company's account.
Yes, my lord, that is his company's account, my lord.
From his company's account.
1.94 crore,
The
15,000.
police authorities as well as the complainant shall also file the respective affidavit giving full details with regard to the petitioner's liability.
fix a time for his appearance before. Lordship had directed SHO to facilitate. Lordship may fix a time or date for appearance, my lords. In the order, nothing.
The shall appear before the investigating officer, shall fully cooperate with the investigation as also for the purpose of gathering the information with respect to the petitioner's liability.
Lord, I have been going to the, my lord, police, my lord, I have facilitated all the investigation. In fact, these proceedings, my lord, happened, all three of us were present. SHO.
Otherwise, we'll dismiss it in a minute.
Pardon, lords?
Otherwise, we are going to dismiss it in a minute.
Lords, I'm so grateful. Great.
यही दोनों फिर अब
This is that case, my lord, which came last week about corporate office and territorial jurisdiction. And also which is observed. An order saying the matter, my lord, may be debatable, but one high court has to hear it. This is that case, my lord.
That's it.
So, my lord, it was kept, my lord, for their instructions today, whether they would agree by consent or the court will make an order. That's why it is adjourned today.
No, sir, I appear for respondents 3 and 4. The state government lost, although in the tendering process, we have very little role to play, my lords. It's for the airport manager, the entity which is managing the airport, which has to do that. So far as we are, yes, sorry, please go ahead.
Let me finish.
No, my lords, our only concern is, my lords, for the future litigation, my lords, there may be.
No, that we will of course.
My lords, under the concession agreement, my lords, the exclusive jurisdiction has been vested in courts in UP. Lords, that the jurisdiction loss is sacrosanct for us, lords, so far as the state government is concerned.
Concession.
And lords, that is the concern that we have.
I have an equally important concern. We are foreign investors who invested in many areas and more than the duty-free shops, fellas. We want certainty. We don't mind, we are agnostic to Delhi or Allahabad. But what will happen is, unless your lordship lays down the law, somebody will sue me in Allahabad, somebody will sue me in Delhi. I may be quite happy with Delhi. So lordship will decide the issue once and for all. Lordship order will mean that it will always go to Delhi or always go to Allahabad.
Actually, there is nothing to be decided. If a cause of action arises in Noida, matter has to go to Allahabad. We are not here to tinker with or take away the jurisdiction of the Allahabad High Court. There is no question of taking that. That if anything happens within the geographical boundaries of the state of Uttar Pradesh, the jurisdiction of the Allahabad High Court or Lucknow bench cannot be questioned by
May I suggest one way out? May I suggest, your lordship, I have got a note with 5 or 7 very important indicia. The lordship doesn't have time today. Don't waste time today, Minister. Put it on a short date. Just look into the note.
I'm sorry, it was fully argued. It's not meant to be argued again. It was only kept
7 for Delhi. It gives 2 or 3 for Allahabad. You've got the GST also. Now, I may be wrong, I may be right, but lordship will decide it at some other's time. Take it a week or 2 weeks later. How does it harm or hurt anybody? It's a jurisdictional issue. I'll succeed.
You know, on the last date of hearing, 20th, on that day, they again filed a GST showing that their office is in Delhi.
We've got the GST. It shows Allahabad. Please show it.
I'll show you. Just see.
Take it in a calmer atmosphere of a day when a lordship has some time. Any day a lordship likes to put it. Take it up after 2 weeks. How does it make a difference?
You know, the idea is only to delay because they've got
jurisdiction.
They've got the contract. It was fully argued in the Delhi High Court, but the High Court delivered judgment, my lord, only on jurisdiction. And I showed your lordship, my lord, exclusive clauses of Delhi. Yamuna was in Delhi. The officer is in Delhi.
Then take my note.
Corporate office in Delhi. Everything is in Delhi.
I don't think it's the right day to argue, but lordship will take my note, fellas. I'll give a lordship to the indicia. I don't think it's necessary to argue.
I'm sorry, my lord, it was not meant for a re-argument. My friend wasn't there. Doesn't mean that it can be re-argued again. My lords heard it for about 40 minutes that day.
Mr. Dave, you are also appealing for the same or?
No, my lord, I am for the successful. I am for the successful lordship I had said the last time. My lord, it's up to my lord, the
he derives from
authority. I take my lord rights from him. That's the problem. So therefore, my lord, we had put across our point candidly to your lordship that everything is, my lord.
So again, my lord, we are back to the same.
My lord, my learned friend may permit. My lord, what is there back to the?
It was kept for your instructions. If you don't, my lord, your lordship will make an order. The way the Chief Justice had proposed. That is one way to make it.
States to take instructions. That's why, my lord, the instructions were taken.
Doctor, you are presenting whom?
I am the Yamuna, SPV operating the airport and basically run by various investors who want certainty in this. Dr. Singh, you entered into an agreement with your eyes open, putting an exclusive clause of jurisdiction of Delhi. Now you argue that Delhi is ousted. That clause may be there. Your lordship is right. ABC Laminate says, I cannot confer jurisdiction on Delhi when none exists.
But then LOI, your corporate offices there.
The man who signed it is
just see this.
What we were trying to avoid is that any judgment we deliver, unfortunately, it will always be misused to the disadvantage of Uttar Pradesh and Allahabad High Court.
Well, actually, your lordship judgment will create certainty.
You can start pushing to bring everything in Delhi, which we all don't want. There is nothing like a special
Just see one page. I'll leave it at that. Just see one page. Just see this one page. I think it requires certainty. I'll leave it.
Which one page? I don't even have it now. I have to now respond, but this is not fair.
Us to argue. Wait for 30 seconds.
They have issued a new tender again.
Para 4. Just one page. Para 4. Subject matter of RFP. Retail duty outlets regarding airport and Noida, Jewar. As far as we know, Noida is in UP. Number 2. issuance of RFP issued from registered office of
Aware of
Yamuna
these facts, there is
at Noida.
Yes,
No, just
all
not the way,
answer
but this is the cumulative
without
impact.
starting the whole thing.
Mr. Rohitgi, this is not the
This is
way.
not fair.
Now,
It's not fair to
clarification,
have a
as
second
per
round.
clause 6.3, clarification regarding the RFP were to be sought from Musale, whose address is registered office in Noida. Physical submission of documents, as per clause 6.4.4, bidders were required to submit a physical copy of the attorney and certified resolution of the board from Noida. Pre-bid meetings, emails issued in pre-bid meetings categorically state that pre-bid meetings would be held at registered office of Noida. Technical presentation on 19th of February, we invited petitioners to give technical at Noida. Rejection of bid on 7th of May, they were informed of rejection at a meeting held on 7th of May at Noida. Issuance of LOI, decision to select the consortium formed by R6 was taken in the registered office of Yamuna, as is evident from the address mentioned in the bottom left-hand corner.
This is also wrong.
And
This is also wrong.
this can't
The
be
lordship
interpreted
said
like
seen it.
this, fellow, when I'm in the middle of a sentence. In the middle of a sentence.
No, you are re-arguing the
Concession-
whole thing which was rejected.
Concession agreement
I'm very
requires
sorry, but
registered
this is not
office
the matter.
and
Which
records
can
to
be
be at
argued.
Noida.
This is
As
not
per
correct.
articles 5.2.4 of the concession agreement
correct.
and as per the Malas issuance of LOI. Now, your lordships put to me, Malas, the exclusive jurisdiction clause which is dealt with in para 5.1. That is the exclusive jurisdiction clause. All I can say is, Malas, laminate and kusum ingots. There are judgments.
Laminate to do with
But
it.
now, Malas, now.
Our corporate office is here.
Sentence while I'm
Laminate.
speaking, Malas, this is not done. He should not do it. Now, Malas, kindly take the GST which is given
Again
to
and
us.
again, my lord, we are
Kindly see the GST. GST is all, he is showing some old GST. Kindly give it
for High Court.
Give it. Are you giving this or not? Give it quickly. Now.
Yeah, yeah.
This is the GST which shows all Noida or UP. Give a copy to him. Now, Malas, I am saying that your lordship.
Because he is showing what is filed in Noida, he also files in Delhi. I showed you the Delhi one, principal place, Delhi.
Malas,
And this is again, below 3 days ago they have filed.
decide
One more.
when we are prepared to win or lose and asking the court to decide something, your lordship will decide it. That's all. There is no jurisdictional issue. How is my learned friend hurt by a decision either way?
Of course, I am heard. For last 1.5 years, we were arguing in the Delhi High Court. But the High Court decided one question after reserving judgment on everything. That's why we were, and my lord will note, my lord, they have issued a fresh tender to select a design consultant last week. That also, my lord, says exclusive that Delhi. They are insisting. It's not a mistake. Going on and on. Give me copies of this. Delhi, this design. You have a copy?
Leave it at that. You guys are foolish enough to do tender for Noida. Not you. Not you. I mean, telling you.
How does that change the law? The law
They don't dis-
You have said Delhi is not laminate. Laminate is the case, my lord. Both of us said, let's go to Guwahati. One of those cases.
Only
And
one-
your lordship may now see, 1 minute please. The new tender they have floated last week with the same exclusive clause.
This is a
What's the point?
contract. That's why we are asking for decide it.
What is there
So
to
we
decide?
change the contract.
What is there to decide when you are going on?
If I
My lord
change
may
the
see
con-
this.
If I
My lord
change
the
the
Chief
contract,
Justice.
he would say that you change it.
My lord, see the last.
No, Delhi. Noida. Noida.
No.
Noida.
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 And signing is sitting in the
Yes.
corporate office at Delhi.
Yes. And the man who signed it is sitting here.
Mr. Musal, I have given the page. Mr. Musale is required.
Please, yeah, please.
Noida.
I showed you all that.
Wrong.
No, I don't want to show it. Show it again.
Actually wrong.
And then see the new tender, my lord. It is dated 15th of January. The new tender. See the next page. Next page, my lord, last
His
item.
statement is sits in Noida.
Item 11. Again says, my lord, laws of Delhi and courts in Delhi will have exclusive jurisdiction in relation to any dispute, which may every time they are doing this.
Side of leave granted. The short question that arises for consideration is whether, in the peculiar facts and circumstances of this case, the petition filed in High Court of Delhi at New Delhi ought to have been entertained, or the chosen bench of the High Court has rightly dismissed the same for want of territorial jurisdiction, thereby relegating the appellant to approach the High Court of Judicature at Allahabad. Excellent. The controversy pertains to the
He says get a decision. Instruction for the contrary. Again and again, I've told him to agree.
Setting up
Tender for duty-free shops.
development, operation and maintenance, maintenance and management of duty outlets
Ask him if I-
and retail outlets of Noida International Airport, Jewar, Uttar Pradesh. The appellant was one of the bidder, and its bid having been rejected, approached the High Court to a writ petition which has been dismissed as noticed above on the ground of want of jurisdiction. Next paragraph. We have heard and senior counsel for the party at a considerable length. Next paragraph. It is well settled and calls for no detailed discussion that mere conferment of jurisdiction on a court including a high court through an agreement between the parties, per se will not confer said jurisdiction. In the matter of maintainability of reproduction, the the jurisdictional competence of the High Court has to be traced out within the contours of Article 226 in bracket 3 of the Constitution, and 2 bracket 2 of the Constitution, which inter alia provides देना क्या है Constitution 40 साल तो पढ़ तो
part of the cause of action.
part of cause of action. It may thus be, which reads as follows. It may thus be seen that the High Court where the cause of action has arisen even in part, is also competent to entertain the petition under Article 226. In the instant case, we find that corporate office of the Yamuna International Airport Private Limited is admittedly located in Delhi. LOI was also admittedly issued from the corporate office.
Admittedly.
No,
It
has seen LOI from registered office.
Don't say that. It's issued from Noida. Well, don't say that.
We can safely
Sure, there are other reasons to send me to Delhi.
infer that all the officers, all the officers who are involved in the decision-making process sit in the corporate office at Delhi.
Yes, that's our case.
It seems to us that the decision to issue the LOI and eventually to accept or reject the bids must have been taken by the senior functionaries of the Yamuna International Airport Private Limited, who, as noticed above, ordinarily sit in their head office. Next paragraph.
According to me, they have to sit in Noida also.
Assuming that these facts are partly incorrect, yet it is not a case where one can say that no cause of action, no part of cause of action ever arose within the territorial jurisdiction of Delhi High Court. And then
Confine it, plus kindly confine it to this case, my lords, and without prejudice to my right in the concession agreement.
He's on.
You
On the contrary, want a law, Malad. We want a law.
Confine it, my lords.
The law we are laying down.
Yes, so therefore we want
May I submit?
That's not correct. Lord, the letter granted to the successful party also says it will be Delhi. If there's a dispute between the successful party, my lord, and them, it says LOA will also be governed by Delhi. That your lordship will find, my lord, at page 624. I showed you that day.
Confine it to this
While
case.
we outrightly reject the claim of the appellants based upon the recital in the LOI that the Delhi courts will have jurisdiction.
No, my lord, sorry. I am saying, my lord, in addition, the concession granted, my lord, to the successful party,
however, it
also contains Delhi.
However, it seems to us that because of some vagueness created by the overlapping of facts, it is not a case where the jurisdiction of the Delhi High Court can be easily ousted. Next paragraph. We therefore, in the peculiar facts and circumstances of this case, especially when the petition has remained pending before the High Court for a good amount of period, and thus it makes out a fit case to invoke our power under Article 142 of the Constitution, we allow the appeal in part, set aside the impugned judgment dated 17 December 2025, and request the High Court to proceed with the decision of the writ petition number 8049/2024, including any other connected petitions or applications.
Yes.
On merits, after hearing learned counsel for the party.
Within 4 weeks or 8 weeks, because they have already got the contract, 1.5 years have gone. If you also may make an order, my lord, within 4 weeks, 8 weeks.
We must clarify that this order shall not be construed that in every case where respondent number 5, where the Noida, where 4, 5 or other contesting respondents would enter into any, would issue any bid, LOI, will issue any tender and or enter into any contractual obligation, this will automatically confer jurisdiction. Automatically, or even if they agree to in writing, on the courts in Delhi, including the High Court, in the High Court, irrespective of, notwithstanding the fact that the tender was floated and the subsequent activities took place in Noida and or other part of Noida or at a place outside Delhi, Also, outside Delhi. Question of territorial jurisdiction thus will essentially depend upon the facts and circumstances of each case, and this order shall not be a binding precedent.
I am deeply obliged.
For other matters.
I'm grateful. My lord, some time limit may be granted, my lord, because it's remained pending for nearly 1.5 years. Then the judgment came. I had to come earlier because High Court was not deciding. Now, my lord, tender is granted. If more time flows, my lord, other equities are raised. My lord, you can observation in 8 weeks or something, my lord, it can be disposed of. The chief bench had actually heard it.
Next item, my lord, 22.
Goes ahead.
Next item, 22, there's some urgency, my lord.
22, Malad, I am in that matter, Mr. Wilson is with me.
Yes.
But this is that UGC matter. This is that UGC matter, Malad, where there is urgency because regulations not applicable are being applied. I'm the petitioner and that's why I'm standing here. Item 22. It's the Tamil Nadu UGC regulations which have been held. Your lordship's matters are pending and a learned single judge nevertheless goes into it and passes an order contrary to your lordship. Lordship just list it on some day, Malad. 22.
I have no. Lord, about 16. Lord, 16.
by the
Lord, 16 universities.
22.
Lord, may I say this, my lord? Some urgency. Lord, some urgency, my lord. 16 universities, my lord, we don't have vice chancellor at all.
That side.
For past 7 months, my lord, this matter, my lord.
No, tell us when do you want to be listed?
Lord,
Whatever soonest date, Malad.
No, my lord, the earliest date possible.
Earliest date.
This is a case where we are deemed assent to those bills. My lord, thereafter the single judge, my lord, the High Court has stayed the operation of the Act. We have come here. My lord, 8 months have gone by. Large number of universities in Tamil Nadu are without chancellors. Vice chancellor.
4th or 5th.
high above the board, my lord, subject to your lordship.
4th February.
Grateful. Very good.
High above the board, my lord, subject to your lordship's convenience, my lord.
The 25?
That is.
Item 17, that Karnataka matter. So who is not filing report? I think that has been done.
Item 17.
But have they not sent the report? The report has been sent probably.
No, Malad, to the best of our knowledge, till yesterday, no. Report is not the EC's recount report.
Recount report.
This is what I'm.
In terms of which order are you talking?
Yeah, well, let's check. Unless it has come.
In terms of which order?
Your Lordship's order of 14/10/2025. Unless it has come, well, it's totally unknown to us.
I'm sorry, which matter is
I don't think the other side has said that it's come.
But there was also.
Just put it on the board.
Count. There was a direction.
25 is on, I think.
Continue.
17. 25 is on.
No, no.
I'm just.
I'm on 1/7, Mellis. Well, whatever is the report, it should come and your Lordship should list it.
Who is to produce the report? So
EC, Election Commission.
Election Commission, State Election Commission.
No, this is government, ECI, Mellis. Oh, I see. Now, Mellis, perhaps is mentioning has produced this report.
Report.
It has come right now in front of your Lordship.
Report is there.
No, I'm glad.
If I remember, last time it was mentioned, probably the report is.
No, your Lordship, Mellis, has passed an order. Please
Well,
take it on
we
record.
will keep it next week. We'll open the report in the.
Yes, please do.
On open court,
please.
and then we'll see what is to be. You bring it on the next date, 4th or 5th of
First week
February.
of February, any time Lordship will give a date, Mellis. First week.
Keep it at the.
Some date your Lordship may give.
Yes, 4th or 5th we will try.
All right, yeah. 4th or 5th, your Lordship.
Item 25.
25, we are, Mr. Narayan and I are amicus in this. This is dealing with the Consumer Disputes Forum. There are two separate matters, both of which we are amicus in. This particular one is dealing with the pay and allowances. And there is a
But some of the states have filed applications for modifications. Some of the states have filed applications for modifications.
Yes.
Punjab has filed.
Yes. Yes.
That we can invoke. In Sikkim matter we are talking.
Yes.
In Sikkim, we will direct that the junior most judge of the High Court, single bench will decide the matter, and against which the appeal in NCDRC, whatever it is, will be heard by the division bench presided over by the president of the commission, who is the former chief justice.
So I have a suggestion regarding that. The 19th May 25 judgment of your lordships became final. Now, many states filed applications for modification. Somewhere or other, some line has to be drawn, my lords, because I believe that it can't.
Says what?
The 19th May 25 says what are going to be the pay and emoluments for state commissions, chairpersons and members, and said that it has to be consistent across the country. This is pursuant to what we had shown them statistically, and the government of India also showed them statistically. Now, it cannot be, I believe, that a state can come and say that, look, we don't have too many cases, therefore allow us an exception. That's what Sikkim and many of the other states have come and said.
Gopal,
yes.
If there are no cases, why the states, after all taxpayers' money, a retired person will just enjoy there. Look at the, let's be very practical.
Yes.
The High Court doesn't have work there much. That's why we will keep busy the learned single judge of the High Court. He will decide the matters. Appeal can come. You see, after all, it's your.
No, fair enough. So if your lordships believe practically that's a way out.
Form should be available.
Then
a person should not be left remedy.
No, I agree. So we have a situation today in Sikkim, for example, where it's being presided by a administrative non-judicial member, and they have been hearing matters over the last 1.5 years after the wrong. That is wrong. But they have put it as a badge of pride in their reply, which they filed in the NCDRC. In my view, that shouldn't be happening. We should have a solution.
That's IPF for Sikkim.
Yes.
So, Mr. Patil, let's be out that all your district consumer complaints will be heard by a district judge, serving district judge. The matter should be entrusted to them. All the state consumer commission appeals or original complaints will be heard by the sitting judge of the High Court, junior most judge of the High Court. Let them also remain busy. And appeals against that will come to the National Consumer Commission to be heard by the presiding judge, the president of the commission, who is a former chief justice of the High Court. That is the only way out we can. Meanwhile, we can grant liberty to the any pro bono citizen that in case the matters increase and it justify the setting up of an independent commission, in that case the matter can be revived.
It's in fact.
Can bring that to our notice, Manoj. We'll revive it. My suggestion is only this, because there are large number of applications. Today it's the Sikkim matters and the NCDRC has said we'll post it on 30th, so to solicit orders. My suggestion is, because we'll have to draw some, I don't want other states to come who are larger states to say, look, the same thing applies to us. We have to draw some division. So if your lordship would list all of it together, maybe someday next week.
About Sikkim also, just think of, this only,
Yes,
we may also
yes.
not necessarily pass an order and then we start.
No, absolutely.
Just examine the implications of this order, you can.
Yes.
It is the proposal, just while sitting in court, it came in mind.
Yes.
That if there is no work, then this is how we can do it.
Well, it's what.
And we list on a day all the applications.
Because all with the states.
State wise, then we will take up.
Yes, please do.
And then you also keep ready the data, how many complaints
Yes.
are pending statewide. We will
Yes.
see what is
We'll
the
get-
justification, to what extent, how many benches are required.
We'll do that.
People can't be left remediless. We say,
Yes.
one of the social welfare legislation, it must be given full effect.
Absolutely.
Lord, may I just come in on the Sikkim application? I was the applicant, my lord. The NCDRC has kept it pending and said that if no order comes from this honorable court, then they are likely to transfer it. So that part of the NCDRC order may kindly be kept in abeyance.
Now, meanwhile, transfer of the matters from the state of Sikkim, meanwhile, no matter from the state of Sikkim shall be transferred to other states.
I'm good.
No.
Obliged.
That's not like it.
And in that matter, there will be no intra-court appeal. The junior was, because the High Court is comprising three, so we may not take intra-court appeal to the High Court. That will not be, that would be alien to the scheme of the statute.
Correct.
One second. What's exactly happening?
There are 2-3 urgent matters left, item 28 and 44. 44 is over, so 28 is left. We will take up 28 after some time. Come back and then we'll take up item 2. And followed by then SIR. And no other matter.
The rest of the matters will stand adjourned, madam.
All our matters will be adjourned. Only 28 pertaining to acid attack victims, that matter they are there. We'll take up after some time.
My lords, we mentioned item 20, my lords, this matter.
All other matters will be adjourned except part of the matter of SIR.
There's an urgency in item 26.
Twenty.
So, Milords, we are in receipt of some affidavits from the High Court. And, Milords, what we would request is there is no reply from the Solicitor General, his.
Just tell me what happened in that her personal matter in this, Rohini?
Yes, Milords. So, in that, the final judgment has been delivered and all the accused have been acquitted. So, she has filed a criminal appeal now and it has been filed before the High Court.
सर मैं 16 साल से अपनी लड़ाई लड़ रही थी पर अनफॉर्चुनेटली एक्विटल हो गया उसके अंदर। आपने पहले इस केस को काफी सीरियसली सुना था सर। मेरी रिक्वेस्ट है कि हाई कोर्ट में मैंने फाइल किया है, अगर वो स्पीडी हो जाए टाइम बाउंड मैनर में तो मुझे फिर 16 साल जिंदगी के नहीं देने पड़ेंगे सर।
हाई कोर्ट में फाइल कर दिया है?
हाँ जी सर, फाइल किया।
आपने अपना एडवोकेट किया है कि आपको हम आपको कोई अच्छा एडवोकेट करके दे दें वहाँ पे?
सर
वहाँ का टॉप का एडवोकेट दूंगा, जिसको आप नाम लोगे उसी को सरकारी खर्च पे कर दूंगा।
ठीक है सर, ठीक है।
आप अपनी चॉइस के वहां से 4-5 एडवोकेट्स का पता कर लो।
जी सर।
1-2 का मेरे को भी नॉलेज है
जी,
लेकिन आपकी चॉइस पे जाएंगे हम, जिसमें आपका ट्रस्ट और फेथ हो।
जी सर।
उसको हम लीगल एड काउंसिल के तौर पर, लीगल एड नहीं, उसको हम स्पेशल फी सैंक्शन करके उसको दे देंगे हम उसको केस
ठीक है सर,
लड़ने के लिए।
ठीक है सर।
बाकी उससे ज्यादा तो हम कमेंट नहीं कर पाएंगे अपील पे
जी
लेकिन वो रिक्वेस्ट करेंगे हाई कोर्ट को जल्दी सुनवाई के लिए।
सर आई वॉज 26 ईयर ओल्ड जब एसिड अटैक हुआ था। अब मैं 42 की हो गई। मैंने अपनी जिंदगी का सबसे कीमती वक्त इस लड़ाई में दे दिया। मैं चाहती हूँ सर कि अब कम से कम जल्दी फैसला हो जाए ताकि मुझे पता लगे कि इन द एंड में कहाँ पर हूँ। मैं हारी हूँ, मैं जीती हूँ, मैं बीच में हूँ सर। आज तक
आपको कोई जॉब नहीं मिला? कोई
सर मैं जॉब तो नहीं, मैं एनजीओ एक चलाती हूँ जिसमें एसिड अटैक सर्वाइवर्स के लिए काम करती हूँ सर, उन्हीं के रिहैबिलिटेशन के लिए, और फिर इसीलिए ये PIL भी फाइल की थी सर।
Lords, may I issue any directions to the Honorable High Court to like wind up the matter in a time-bound manner, expedite the hearings?
First file the appeal and then after numbering etc.
Yes.
Then you bring it on record.
We already have a diary number.
See, just think of it that today if we pass an order, will it might not cause some prejudice somewhere. Just think of it, let the notice be issued, or when it comes for date for argument, and when you, meanwhile you can tell the name of the advocate. For that you need not to wait the next date of hearing in this matter. If on Monday or say day after, if you are able to make up your mind that who is the counsel you want to engage, in the 10:30 you can make a mention. The matter may not be listed here. You make a mention, we will take up it on board, we will pass some order, we will request the legal service committee to engage and do the needful, right? That will be done. Once you engage the counsel, then let us see how it proceeds.
So, Milords, in the rest of the matter, let me mention that we have received around 14 to 15 affidavits from the states. But on the whole, when I was going through the affidavits which have been filed, the data which has been collated, so what I could come to see is the oldest matter which we can relate to is from 2014 or 16. That is the oldest matter which we can relate to. So, Milords, there is a chance, there is an impleadment application also which has been filed recently. So, in that matter, the case pertains to 2003 and that matter is also pending, which pertains to acid attack, and it was not included in the affidavit filed by Calcutta High Court. So, Milords, there is a chance that acid attack victims who might not be included in 326A and B, which came into enforcement in 2013. After the criminal amendment. So, Milords, I think that acid attack cases might have been left out by the High Courts, which are not being covered under 326A. Because before 2013 amendment, all the acid attack cases were either being taken up under either 307 or 326.
Lords, I appear in that IA which is being mentioned currently. Your Lordship, 2003 onwards, it's been pending. I must in fairness submit, my Lord Justice Bagchi had passed certain orders. While this person was sleeping, his wife had poured acid in his eyes. Your Lordship may be able to recall.
I am appearing for the High Court.
if my learned friend can give me a copy of the application,
Yes.
then I can take instruction about the matter.
You see, what is alarming is that the Calcutta High Court or the, no, Allahabad, of course, Allahabad is very big High Court. Allahabad has 198 matters and Calcutta has 160, which comparative to other High Courts is very huge.
Find out that on 90 out of 160.
Sentences are 70.
Giving you homework in the sense that out of the total pendency, how many matters are of 7 year and above?
Yes, Lordship, we have given in our affidavit, para 4, Lordship, out of 160, 60 have been registered after 2020 and 30 after 23.
All right, then can you constitute one dedicated single bench for deciding all the pending these appeals?
We can take instruction. We will I'll communicate and if there is taken.
Who is representing Allahabad High Court? You also need to do something.
Please,
Huh?
About 70 odd districts,
Not that
we will take some.
198 appeals are not as an unmanageable affair.
Please, my lord.
You can constitute two benches. In fact, in Calcutta also, one bench for TV matter, one for single bench.
These 190 cases are in various district courts, my lords, because the trials are pending across 74 districts. So across 74 across 74 districts, 190 cases are pending in the trial court, my lords. But any order from your lordship, my lords, it will be expedited, my lords, because there are trials which are pending in various districts, my lords.
But
Please, my lords, your lordship's last order.
These are not High Court matters.
Not High Court, my lords. Your lordship's last order had directed the cases pending in trial.
Do one thing. Well, because this, we don't want to interfere in High Court's functioning, that's their prerogative. If they issue some instructions for expediting and making a time bound to conclude the pending trials, that will help a lot.
Please, my lord.
If you take a decision, we can then issue directions to the court on judicial side, ensuring compliance of those issues.
Please, my lords. We'll
Let them, all High Courts take a decision.
we'll instruct.
Say, pursuant to the order dated 4th December 2025, most of the High Courts, say 15 High Courts have sent the details of pending cases concerning the acid attacks. Maximum cases, that is 198, are pending in state of Uttar Pradesh. In West Bengal, there are 160. Whereas in Gujarat, there are 114 cases pending. Bihar and Maharashtra have 68 and 58 such cases pending respectively. The status report from other high courts are still awaited.
Rajasthan High Court also it seems like.
Rajasthan High Court has not filed, no, Rajasthan has come, Rajasthan only 12 cases.
12 cases.
12 cases.
Meghalaya High Court has also filed. Jharkhand is not reflected in the.
We request the High Courts to consider.
Jharkhand High Court also filed, my lord. Jharkhand High Court, my lord.
That's why we are saying 15 have filed. We request all the High Courts to consider the desirability of issuing and taking an administrative decision for expediting for and concluding the trials in the matters concerning acid attacks in a time-bound manner on out-of-turn basis. So, we have our leave it. All the state legal civil authorities are directed to submit a report with respect to the scheme, if any, implemented by them for rehabilitation, compensation, for grant of compensation, rehabilitation, and medical aid to the victims of acid attack. If no such specific scheme has been formulated so far, we request the executive chairperson of the state legal service authorities to do the needful and submit a compliance report.
Regarding the compensation, it is already being covered under the NALSA scheme. Which
But do they have, do they have the sufficient funds or not, and are they implementing, how much are they giving?
Paid actually from the NALSA fund.
You see, if the compensation amount is only, is a symbolic and
Yes,
it is no use, then
they restrict it only to the medical reimbursement part. The compensation, as in the original meaning of compensation, is not taken into consideration by any of the DLSAs. So they go by the statute, by the book.
why don't you suggest, what about the assets of the accused? Why they should not be attached permanently and
It is upon the prerogative of the trial court. So in most of the cases, because these people come from a lower state
just
of.
examine
Yes, ma'am.
that what should be the legal position, that in a case where if a person is found guilty of committing the acid attack, why all his immovable assets be not acquired, be not resumed, and be auctioned in a transparent manner to compensate the victim?
In actually most of the cases, the accused are also belonging to the lower strata of society. So the question of obtaining any, being in possession of any immobile property is very less. The chances are very low.
No, we are only on the legal issue. What are the assets, whom they belong, how they have been siphoned, all these things will be done by the local police.
Yes.
When the FIR is registered and the accused is taken into custody, they must obtain, we can make it mandatory that they will simultaneously obtain the details of the assets, and along with the charge sheets of the list will be submitted, and then there shall be embargo on creating third party rights on such assets. You have to take some extraordinary punitive measures beyond the letters of law. You have to take something. Unless the action is so painful for the accused,
तब तक सर ये
it's
crime
not going to. These are the matters where like the doctrine or the principle or whatever you call the theory of the different theory must be followed. There is no, this reformative theory has no place here. One should be extremely harsh.
Yes, sir.
The system, the court and the police all.
सर एसिड अटैक इतना पेनफुल है फिजिकली भी मेंटली भी कि इसे बता ही नहीं सकते हैं मतलब हद से ज्यादा पेनफुल है सर आइडेंटिटी को लेकर अपनी आइडेंटिटी खो दी इतनी 25 सर्जरीज मेरी हुई हैं अब तक हर बार ऑपरेशन थिएटर में जाना इतनी महंगी महंगी सर्जरीज और इतना पेनफुल है कि मैं खुद नहीं बता सकती हूँ और सर मैं तो फिर भी एक आंख से देख सकती हूँ ऐसी भी लड़कियां जो कंप्लीटली ब्लाइंड हो गई हैं और वो बैठी हुई हैं सर कुछ भी नहीं है उनको कोई कुछ उनका रिहेबिलिटेशन के लिए कुछ भी पॉलिसी नहीं है
Why let the states give us the status of all the acid victims, the current conditions prevailing. इसमें लिखो all the states and union territories are directed to furnish a list of to furnish the following information. One is the incidents of acid attack reported in bracket year wise. So whether charge sheets in those cases were filed or not. 3I, how many cases have been decided and how many are still pending at the trial stage. Next, how many appeals arising out of the trials of acid attack victims. Acid attacks are pending. Next. The brief particulars of each victim of acid attack, her academic qualifications, current status, employment status, marital status, the medical treatment, the details of the expenditure incurred or committed to be incurred by the state on such treatment. Next, main heading में बनाना rehabilitation scheme for the victims of acid attacks, if any. So let us get this information, then we'll see what is to be done.
Coming to original prayers in the acid ingestion, Lords may issue any directions for consideration of those victims of forceful acid ingestion in the disability criteria till any new policy comes into force.
Direction regarding?
Because the victims of forceful acid ingestion, the victims who have been forced to consume acid, they may be considered under the disability criteria and a disability certificate may be issued to them. Any directions? Presently they are excluded.
इसमें लिखो the states are further directed to furnish a separate details including particulars of the victims of forcefully consumption of acid. Let us see how many matters they report.
Just a small request, Your Lordship. Malats, I understand that most of the victims are women. And however, in my case, it's a man, Malats. So Your Lordship may make that general note, the direction which Your Lordships have passed.
Yes, my lords, because not only men, there are children as well who
Children
have.
also, it can be old senior citizens also. Persons कर दो उसमें. Persons कर दो. Mostly cases, the young girls have been targeted.
Your Lordship.
Let us get this information and this the needful shall be done by the state governments as well as the high courts within a period of 4 weeks. Within a period of 4 weeks. Madam Archana, you find out and see their own Union of India and you give your own suggestions also what is to be done. Yeah. What can there be a dedicated purpose for assisting these victims? One, to think of some legislative intervention. Legislative intervention, one first intervention should be shifting of onus. It should be treated like they should be treated not less than serious than the dowry death also. So that shifting of onus must be there. If you are able to do it, it will have a lot of. And why there should be a general sentencing policy in this matter? Why this should not be carved out as an exception to the general sentencing policy? You also assist us in the matter. So we'll take up after 4 weeks now.
Grateful.
Me.
Yes, Mr. Maninder Singh. Unfortunately, the time has been reduced from now 10 minutes to 8 minutes.
That's your lordship magnanimity, my lord. I thought that Mr. Dwivedi has covered everything, my lord, so nothing.
No, but still.
Yes, my lord, I'm only focusing on, my lord, for your lordship's assistance, if on section 21. It's, my lord, relatability to section article 324.
On one of the dates, Mr. Naidu said, I am also appearing for the election.
That was, my lord, something where the other side,
He said one day, but he never comes after that.
I'll just complete in, my lord, not more than 10 minutes. Just have a look for your lordship's convenience. I've prepared a small compilation. And then, my lord, 2-3 paragraphs, my lord, which your lordships have been told, but I just want to read it with your lordship permission. My lord, if your lordship may kindly take this short note which I have prepared, my lord.
That's it.
Now, my lord, your lordship may kindly permit me to very respectfully urge, my lord, that what your lordships are considering is what is a special revision. Now, is it special revision which is conditioned by the parliamentary made law under Article 327 in the form of 1950 Act or rules, or is it a root and a key to bring back the jurisdiction of the Election Commission directly under 324, of course, subject to the principles of non-arbitrariness and, my lord, the reasonable. That is what I have tried to do it, my lord. Just have a look at page 1. My lord, page 1, my lord, para 1, Mr. Dwivedi has already submitted in detail, my lord. Every, my lord, in my respectful submission, every nation has a policy. It is every sovereign nation has to decide.
One thing have also been explained.
Yes, my lord. And kindly see, my lord, the conditions which are Article 326 conditions, my lord, they are essential conditions for your entitlement for inclusion in the electoral roll. This, my lord, condition, fulfillment of these conditions is a continuous requirement. You cannot say once my name has entered, whether I have lost any eligibility or not, and therefore I must remain there. I am entitled to vote in every election, even when there is a verification exercise to see of continuous fulfillment of those conditions. Then your lordship may kindly come to the next page, para 6. I have only for the convenience, my lord, please see the left side column.
Comparative.
These are the constitutional requirements which are re-emphasized and reiterated, my lord, on the second column by the legislative provisions. Then, my lord, Article 325 is couched in negative, that you will not be ineligible to be included on these conditions. Just permit me to read that table, my lord. No, that is 325 in para 7. No person shall be ineligible for inclusion in the electoral roll only on grounds of religion, say, race, caste or sex. So this is, my lord, in the negative, that you would not be ineligible on these grounds. Important is 326, where, my lord, those three conditions which are constitutional essential conditions, my lord, which are required for, my lord, entitlement for being registered in the electoral roll and at any election means at every election. Then your lordship may kindly come to the next page. My lord, on the top, that any would mean every in such context, that is the two lines, the last two lines of para 8. Then, my lord, kindly see 21.1. My lord, 21.1 is preparation. 21.2 is a revision. 21.3 is a special revision. Now, my lord, if you
21.1 is original.
First electoral roll.
Original.
Yes, my lord.
21.2 revision.
Revision. And the state of that
special.
And 21.3, my lord. And then, my lord, if your lordship may just make a note of para 13. I am not reading it at the same page.
Yes.
And, my lord, in para 13, the terminology of as it thinks fit, my lord, the judgments are only mentioned. I am not reading it. Please come to page 4. There, my lord, I want to make a submission with regard to para 14 and 15. So, my lord, 324 is the wide and plenary jurisdiction of the Election Commission. By virtue of 327, parliamentary intervention. But, my lord, it's my respectful submission in supplementing what Mr. Dwivedi, our leader, has leader of the team has already mentioned. 21.3 is the route, my lord, to bring it back to 324. And, my lord, if I can have the permission of Justice Bakshi to use the terminology unshackles. See, the conditioning on 324 by virtue of 327 is the 1950 Act and the 51 rules. 21.3 is the parliamentary mandate that there would be situation which we can't see today, where that jurisdiction that is described as plenary and wide under 324 would be required to be vested in the Election Commission, a constituted authority once again. But yes, subject to the principle which your lordships have reiterated time and again, reasonableness and non-arbitrariness. Now, my lord, Lal Babu is mentioned in para 18, para 19 of this, one para, my lord, which I wanted to rely and emphasize further. I have quoted it, I am not reading it, my lord. And then with regard to, my lord, the distinction between citizen and non-citizen on the basis of Mr. Dwivedi has also argued that a citizen-centric is para 22, where, my lord, one para of Sonobal, my lord, which was, my lord, I thought that there is emphasis needed. I have quoted it, I am not reading it. 24 to 27, my lord, I want to make a submission. My lord, the EVM case had already stood and decided a number of times. My lord, the apprehensions always used to be expressed about the working of the EVM, and that also became a cause of, my lord, too much of discrediting the Election Commission of India. And there I wish to read, my lord, the few paragraphs of the last judgment of the then Honorable Chief Justice Khanna and, my lord, Justice Datta. I want to come to that, but your lordship may just permit me to say this. My lord, Article 32 in such matters, your lordships have exercised jurisdiction on umpteen times, and it is required to be carried out. My lord, but the test which is laid down in this EVM on such repeated, my lord, discrediting exercises, which my lord, found observed to be prima facie far from being bona fide. That, my lord, in my respectful submission, has repeated here again, and your lordships have stood satisfied, my lord, in our understanding that when this SIR in Bihar started, similar apprehension, my lord, and primarily only on the basis of the news reports, no other material which could, my lord, test the scrutiny by the court. These three paragraphs, my lord, 24 to 27, I am not reading it, I am emphasizing it. Please come to the next page, my lord. Annexure A. Now, my lord, on the top, your lordship will see section 21. This is the title of 21, which includes of two components, that is preparation and revision. 21.1, my lord, on the first column, I am not reading it. Your lordship may just see that is with regard to preparation. 21.2 is in the second column, where your lordship will see the most important terminology shall be revised in the prescribed manner, which your lordship, my lord, even Honorable Chief Justice said that it is used twice over in 21.2. Which, my lord, if your lordship come to the third column, now 21.3 in comparison to 21.2, then, my lord, first of all, non-obstante clause, to keep it away from the exercise under 1950 Act and the rules made thereunder, in such manner as it may think fit, and the outcome, my lord, in this, if your lordship come to the next page, last page, my lord, the last page of this, you can skip the other page, kindly come to the last page.
Yeah.
Now, my lord, kindly see, 324 jurisdiction is there, then it is conditioned by 327, subject to the provisions of 1950 Act. For revision 21.2, 21.3 is a special revision, which in my respectful submission is once again a parliamentary mandate that we restore the jurisdiction as it is 324 for special revision. 321, section 21.3 is the key to go back and enter that room, which, my lord, is on the right side. Now, my lord, only two paragraphs which I just want to flag, my lord, and not read. In the judgment, my lord, in the EVM case, my lord, this is in volume 5R. I requested, my lord, it is taken out. 5R starts at page 108. Kindly come to page, my lord, the top page, my lord, which is running of this volume, 146 from para 80 onwards, 80, 81, 82.
Yes.
And I want to read, my lord, if your lordship permit me, para 81. Mr. Dwivedi had pointed out, my lord, but since I had the privilege to make submission before this honorable court in this case, so I am tempted to, my lord, read it para 81. I place on record that although such a suggestion was subsequent, this was, my lord, that if what eventual relief is being sought by the same petitioner before the Honorable Supreme Court, the answer given was going back to the paper ballot. I place on record, although such a suggestion was subsequently withdrawn by the council in course of proceeding that ensued following listing of the writ petition. Here also, my lord, the jurisdiction first of all. So many counsel on the other side have argued we are questioning jurisdiction. Others have said we are not questioning. Then, my lord, my friend Mr. Bhushan said that he gave in written submission, he is questioning, and then said, I am not questioning. Same thing happened there also. I place on record, although such a suggestion was subsequently withdrawn by the council in course of proceeding that ensued following listing of the writ petition for direction to seek clarification of the ECI on certain point, nothing much turns on it. The withdrawal was more of an attempt, please mark it, my lord, to erase the impression we, the judges forming the bench, were urged to form by the senior counsel by the ECI while arguing that petitioning associations utter lack of bona fide in invoking this court's writ jurisdiction under Article 32 of the Constitution is completely exposed to thereby. I have no hesitation to accept the submission of the council for the ECI that reverting to the paper ballot system of the bygone era, as suggested, reveals the re-intention of the petitioning association to discredit the system of voting through EVM and thereby derailing the electoral process that is underway by creating unnecessary doubts in the mind of the electorate. It is of immediate relevance to note that in recent years, a trend has been fast developing of certain vested interest groups endeavoring to undermine the achievements and accomplishments of the nation and through the hard work and dedication of its sincere workforce. There seems to be a concerted effort to discredit, diminish, and weaken the progress of this great nation on every possible frontier. Any such effort or rather attempt has to be nipped at the bud. No constitutional court, far less than this court, would allow such attempt to succeed as long as it has a say in the matter. I have serious doubts as regards the bona fides of the petitioning association when it seeks a reversion to the old order, irrespective of the fact that in the past efforts of the petitioning association bringing about electoral reforms have been borne fruit. The suggestion put forth appeared inexplicable. Question of reverting to the paper ballot system on the facts and circumstances does not and cannot arise. It is only improvements in the EVMs or even a better system that people would look forward to be in the ensuing year. Then, my lord, your lordship, may have just two more paragraphs from 97 at page 151. 97 to 100. There are two other ancillary issues which are to be added, para 97, 98. The first is the very issue of maintainability of writ petitions of the nature presented before us. Should mere suspicion of infringement of a right be considered adequate ground to invoke the jurisdiction? In my opinion, the answer should be no. A writ petition ought not to be entertained if the plea is based on mere suspicion that a right could be infringed. Suspicion that a right could be infringed and a real threat of infringement of a right are distinct and different. And then, below para 100, your lordships have laid down the guidance. So, my lord, in my respectful submission, from the date when these petitions are taken up earlier and with the orders which under the guidance of your lordships which are passed, please apply this test, my lord. In our respectful submission, these are not the petitions with any bona fide. These are the petitions more, my lord, to some kind of a design to discredit the constitutional body, and therefore, my lord, it should not deserve any further indulgence by this honorable court, my lord. I am deeply grateful to your lordship.
I am also appealing for election commission in 301.5. Only 2 points I will say. I only point on this constitutional consistency and the legislative intent was also there, and the SIR, there is a departure therefrom. Your lordship, I have given also a brief note. Yes, there is a note I gave, but I will not read the entire note, your lordship. I will just read as 326, your lordship, says, which limits the voter registration to citizens or otherwise disqualified. That also was the intent from the beginning at the time of enactment of 1950 Act. In fact, I have annexed your lordship the parliamentary debate. Kindly see that starts at page 12. From page 19, there are 2 pages I'll read your lordship. Page 19, bottom. Dr. Ambedkar, that now I come to registration of voters. Whether 16 will come first or 19 on that, your lordship. The principles adopted for registration of voters for parliamentary constituencies as well as the state legislative assembly constituencies are the same. There is no difference. Consequently, I think that it would be enough if I explain the provisions relating to registration of voters for parliamentary constituencies. The first principle is that is laid down in clause 15 of the bill, which says that every constituency is to have an electoral roll on the basis of which election will be conducted. The preparation of electoral roll is therefore an obligatory thing and a condition precedent for election. The second principle is that for being registered on an electoral roll, a person should not suffer from any disqualification mentioned in clause 16. So that is citizenship, your lordship. He should not be a person who is not a citizen of India or a person who is that is not relevant, etc. The next principle is that a voter can be registered and that in one and not more than one constituency. Again, in that is 19, your lordship. So these are 3, and this is also reiterated, your lordship, at page 24. Again, in another answer to another question. The question, Dr. Ambedkar, this is the bottom, your lordship, last 2 questions at page 24. Sri R.K. Chaudhary, Assam. What about the displaced persons who have come to India now? Because at that time, your lordship should imagine that even the Citizenship Act was not there. And that time, this is the thinking of the legislature. But about the Ambedkar, if you are raising the point, I'll explain it now. We have provided, as you will see in clause 20.6, that anybody who has come to India before 25th July 1949 will be entitled to be registered as a voter in the constituency in which he resided on the date or in any other constituency which he may specify to be his own. What about those who are coming now in 1950? Dr. Ambedkar, what we cannot do, because under our constitution a voter is required to be a citizen. And our citizenship clause defines citizenship as on the commencement, unless we have a new citizenship law to regulate the position. Those who have come after the date, I am afraid they will have to go without it. So this was the intent from the beginning, and your lordship SIR, in fact in the recital 5, 6, 7 and 8 have said the purpose also, because 21.3 requires to give reasons, and the reasons are well contained, and citizenship is mentioned in at least 3 recitals, 5, 6 and 8. 7 doesn't include that. So therefore, your lordship, that is the purpose and that is the consistency. Your lordship should see that the IAs which were filed only created, your lordships, the process more cumbersome. Otherwise, your lordships, as far the outcome is concerned, there is not a single objection, not a single appeal, etc. So therefore, a vote has voted without any grievance, and therefore this exercise under 32 and those IAs, your lordship, probably add to the difficulties in this exercise of the SIR. Thank you.
Thank you, Mr. Kumar. Yes, Mr. Naidu.
May I please, Millets? Millets, this is the place, Millets, in this country, especially the constitutional courts.
5 minutes?
Millets. Yes, Millets. I'll coincide with 4 o'clock.
Little early, I will add Mr. Ansariya will also add something.
Okay.
I will not be able to. Sometimes at least I will come.
Oh, you will praise it, we know very well. You
As my lords indicate, Millets, I'll run through. I've just placed before your lordships, Millets, some written submissions. To preface my submissions, Millets, in this country, Millets, the constitutional courts Their doors have never been shut for anybody and everybody. They don't require any particular qualification to knock the doors. And even if they're not articulate, my lords would take care of that one. Somebody else would be given for them at the expense of this institution. But the only thing that's required is that they should have some grievance to ventilate, not to hit the headlines, or not to make a mockery of the system. These are the two things which your lordships have frowned upon. The rest has been allowed. Now kindly see, Millets, coming to the brass tacks at the basics, Millets, the prayer that's been sought in this one. Could my lords have a look at the prayer, Millets? At Millets 222, volume 3A. I'll read, Millets, not to trouble your lordships. In view of the foregoing, the petitioner most respectfully prays that this honorable court may be pleased to call for records and issue a writ, order or direction in the nature of certiorari, quashing the direction so and so, issued by the respondent so and so, call for the record, etc. It goes on. Millets, it is camouflaged as a writ of certiorari. Is there any quasi-judicial order passed as yet on the date of filing of this writ petition by the Election Commission of India? Well, I will liken this situation to something else. Say, for example, in a departmental proceeding, to initiate the process, the authority concerned may issue a notice. That in itself does not amount to an order in exercise of its quasi-judicial power. It is only the process that's been triggered. Once an order has been passed, then Millets, it's amenable for judicial review before your lordships or any constitutional court for that matter. Here, Millets, exercising its constitutional power and the statutory power, which are in abundance, which have been exercised so far 13 times to this day, the Election Commission of India has initiated the process of SIR, Millets, Special Intensive Revision. And Millets, that process, when it was afoot, not the person, not the elector that has knocked the doors of this honorable court, but somebody, the good Samaritan supposed to be, has come here saying that I have an apprehension that they may not do rightly. Can this honorable court ever is inclined rather to interdict a person's constitutional power or a statutory power for that matter in an apprehension that they may not exercise that properly? And Millets, in my humble submission, it is nothing but what they seek from your lordships is a writ of prohibition, not certiorari. And my lords could see what are the grounds that could qualify to earn a writ of prohibition from your lordships. Kindly have a look at the grounds. Whether any of the grounds would pass the muster. I'll just take your lordships. I will not trouble your lordships to any reference. I'll just say that, Millets. What's been said here, the first one only reiterates the scope of 324 article. Nothing else beyond that one's been said. Then ground B says 324, 327, 328. Yes, the ECI has power. They would say that one. Then Millets, kindly come to C. Because the EC's primary responsibility is to be inclusive and ensure universal adult suffrage. The test for disqualification may begin once an equitable and fair process has been applied to create a universal rule. Again, a sort of an exhortation. Then comes Millets, D. Because the process of testing for disqualification is not meant to take primary place at the cost of equitable enumeration. I've just been breaking my brains, Millets, to understand this phrase of equitable enumeration. It's alliteration, beautiful to sound, but I don't think it makes any sense in that one. Enumeration is legal. Enumeration is statutory. Once it is statutory, even for that matter constitutional. Once it is statutory and constitutional, Millets, the question of equity just goes into air. It doesn't mean that we are not equitable, but I still say, Millets, we are being bound to follow the rule and implement that one. So that somebody's difficulty, we have had elaborate mechanism on place, and to this day, Millets, virtually in this case, this honorable court has been cautious enough, vigilant enough, as sentinel on quivi, as my lords have earlier described, to ensure that day to day the whole process has been monitored, elections have been held, and then Millets, the result is there, or for to see when it comes to the process and the lapses alleged ones. Not even a single person has had any grievance to this day, except those who have had a separate agenda. Now, Millets, these are the grounds they go on in this way, saying that when there has been a natural justice violation, when I have not even began the process in this manner, I have just suggested in that one, Millets. Could they visualize that there is going to be a national justice violation? These are the things, Millets. The point that they have urged in the next breath is that, Millets, that when it comes to the provisions, Millets, they say we have not given, when we have issued the notification for SIR, sufficient reasons to justify that one. May I just take your lordships to that, Millets, page 354. Volume 4A, Millets. I will not trouble further, Millets, except for a couple of minutes here. My lords could see what's been said in para 5 of this notification is this. Whereas the preparation of electoral roll must ensure that all eligible citizens are included and no such eligible citizen is excluded from the electoral roll. That is the primary purpose of ECI. The very objective is that one, nobody shut out. And the converse could be somebody who has not been eligible may not be in. It goes without saying. Then, Millets, whereas the Article 326 of the Constitution stipulates that every person who is a citizen of India and who is not less than 18 years of age on the qualifying date and is not otherwise disqualified under any law shall be enrolled to be registered in the electoral roll. Millets, every computer system will have firewalls, so that a particular malware will not enter into that one. As far as this honorable court is concerned, Millets, there are certain firewalls where they have said that the citizen has been robbed of his rights. Your lordship should be really alert. And they would like to impress upon your lordships to that effect, but they failed. This is what I have been submitting. Another firewall they have built for themselves is that, Millets, that we are determining, that ECI is determining the citizenship. Millets, determination is different from verification. If I espouse myself to be a lawyer, then I wanted to enroll at the very beginning. Then, Millets, I need to produce my certificate. And the Bar Council is not going to determine my qualification. It only verifies my qualification. Here, Millets, Election Commission of India, when 18 years somebody crosses, and after 2003, by 2024, they are of eligible voters. And then, Millets, they need to establish prima facie. These are the things that I can show to the authorities to qualify myself as a person. Does it amount, in my humble submission, any sort of determination, Millets? The answer could be a resounding no. There's no such thing as ever been attempted. My lords have indicated, expand the scope of the documents they can produce. We did that one. And any doubt that could be verified. And anybody shut out, assuming against myself that without any justification, there is hierarchy of adjudication methods that have been suggested. And I am told, Millets, not even one complaint with regard to all these things, except grabbing the headlines or an effort to do that one. Nothing else comes out of this, Millets. Now, Millets, I've just pleaded in my page 3 of my note, Millets, what's the distinction between a verification and determination. And ECI has never indulged in any sort of determination of anybody's citizenship. But once Constitution mandates, then the RP Act mandates, that's the primary hurdle anybody has to cross to earn a vote. If you had been there in 2003, you have had right royal red carpet spread by the ECI itself, that you can be a voter, again reaffirmed. But you have come for the first time, you need to have these primary concerns addressed, and then there is a mechanism for you to have that one. And Millets, anybody, my lords, have seen that we are not static. We move about. Many people may have moved, may have shifted, may have migrated, or perhaps may have been dead. All these things have to be taken care of. Millets, the proof of pudding, eats in its lying, is the best thing, Millets. My lords could see in my note at the end, I've given the statistics with regard to the percentage of voting. In fact, Millets, some collateral advantage, as I realize, is that, Millets, the collateral advantage of this SIR. Could my lords come to that one, Millets?
I will talk about page 15 onward.
Page 14, Millets, my lords could see?
Yes.
My lords could see? Para 55 we have explained, Millets. One moment, Millets. Yes, Millets. An electoral roll with lakhs of absent, shifted and dead voters would naturally have a lesser voting percentage than the voting percentage on a clear electoral roll. The rise of voting percentage of Bihar from 57.29% in 2020 general election to the Legislative Assembly of Bihar at 56.28% in 2024 general election to Lok Sabha to 66.91 in general election to the Legislative Assembly of Bihar 2025. My lords could see, my lords, the very next page, the chart that's been given in a tabulated manner at page number 15.
Yes.
It arouses the interest of the common man. Because the whole process, they've knocked every door of Bihar. It served the purpose of weeding out the absenteeism, and also it has served the purpose of drafting in the enthusiastic voter, and that's how, Miller, this percent has been there. Had it been a case of what they just had, this doomsday picture presented before your lordships, it could have been disastrous, much less. It's on the canvas, it's on the rise. That's why, millets, it's an empty slogan on their part with regard to the bogey of citizenship. Only thing is that, millets, in the manner accepted by law, somebody has to establish his credentials to enroll himself for the first time, or after the cutting dates of 1987 and other 2003 millets, that there was whatever had been required, and that's been examined by your lordships whether such requirement is beyond the legal purview. It's not, in my humble submission. Then, millets, my lords, may kindly come to the other aspects that I may just focus on, millets. Kindly come to page 5. Point 4, millets, I've raised. Attempt of petitioners to import the requirement of section 16(1)(b) into 16(1)(a). Could my lords have a cursory glance on section 16, millets, of RP Act 1950? I'll read, millets, without troubling your lordships.
Yes, so come to.
Electoral roll, 16 minutes. Disqualifications for the registration in an electoral roll. A person shall be disqualified for registration in an electoral roll if he is not a citizen of India or is of unsound mind and stands so declared by a competent court. Millet's declaration as to somebody's state of mind is by a judicial adjudication. And it does not, as I'm given to understand, Millet, they say that it should also be in there, that there should have been earlier determination by a competent court that he is not a citizen, etc. You are no person to say that I'm not a citizen. Millet, there are two distinct things. When it comes to a person who has been sane otherwise on the face of it seemingly, may not be. And that's why, Millet, there is a separate procedure for that one. There is a declaration for that purpose. When it comes to citizenship, Millets, it's mandatory. So B cannot be telescoped into A. There are two different things. All that we wanted is a legally acceptable document to show that you can be enrolled as a voter. Nothing more, nothing less. Then, Millets, my lords, may kindly come to page 6, Millets. We have talked about, Millets, section 19. Kindly see that, Millets. Conditions of registration. Subject to the foregoing provisions of this part, every person who is not less than 18 years of age on the qualifying date and shall be entitled, is ordinarily resident in a constituency, shall be entitled to be registered in the electoral roll for that constituency. Another argument, as I'm given to understand, is that, Millets, section 19 does not mandate that he should be a citizen of India, or at least it is not a precondition per se. The very beginning of the sentence, Millets, it's been said subject to the foregoing provisions, and the foregoing provision, section 16, which begins with that one, that's the primary condition. It is only a question of eligibility, and that eligibility may come in different ways as Constitution has mandated. One of the conditions that's been mandated is citizenship. The other one is that of 18 years. Then, Millets, the peripherals come in the course of the statutory provisions, and they could be fulfilled. That's why, Millets, we have given the forms, we have knocked the doors, we have taken the trouble of collecting everything, compiling them, and anybody has any grievance, we have given them an opportunity. They have availed themselves of, and they have been happy. I just may come to the next one, Millet. Kindly come to page 7 of my submissions, Millets. Page 7. Could let's have a look at para 24 of my note, Millets. In this context, it's also relevant to take note of section 62 of the RPA 1951, which is quoted. Right to vote. No person who is not and except as expressly provided by this act, every person who is for the time being entered in the electoral roll of any constituency shall be entitled to vote in the constituency. Well, it's a convoluted sentence. Simply put, millets, everybody whose name is there in the electoral roll is entitled to vote. Then millets, the whole process, my lords may kindly appreciate millets in 75 years of the democratic history of this country, millets, not even a single allegation at any point that elections have been stolen. Even 4 years ago in America, it's been said that when you stole my election, you stole my elections. This is no banana republic because of the sentinel on the qui vive like this honorable court and other constitutional courts, as well as institutions like ECI. And here, my lords may kindly see, once you enter into that one, you determine the fate of the nation as an elector. For that purpose, all that you need to do is just establish that you are qualified in terms of the constitutional mandate and the statutory mandate. Nothing more. Then millets. Sorry. Yes, millets. I may just read millets. One more sentence from this one. Section 62, subsection 2. No person shall vote at an election in any constituency if he is subjected to any of the disqualifications referred to in section 16 of the Representation of the People Act of 1950. Millets, both have been couched. If you have that threshold mark, you are participating. If you fail, you cannot. Well, it's 2003. We have said your name is reflected, no questions asked. And first time you are coming, please provide these prima facie evidence. And if at all any dissatisfaction on your part, you have got the higher echelons to adjudicate your grievance. And every checks and balance have been taken care of. And more so as monitored by your lordships, if I can use that expression. To conclude, millets, I may submit, millets. There is no ground to come before this court. It's entirely premature. Anyway, millets, pending this one, the process has happened. They have also talked about the time frame. Given the technological advances and the manpower at the disposal of ECI, it could, in record time, complete the whole process and then establish that nothing has been amiss. I don't think, millets, even at this stage, they could point out one lapse as far as Bihar is concerned. Bihar, others are in the way, millets. It is to be summarily dismissed. It doesn't deserve any recognition, rather judicial acknowledgement or imprimatur from your lordships, millets. I am grateful for the opportunity.
Thank you.
Fellows, may I please?
You also want to add?
Fellows, would your lordships allow me to submit today?
No.
Maybe I can continue to.
Okay, go ahead, go ahead.
Fellows, the difficulty in following seniors of such repute is that there's nothing really left to argue. But one point which remains, which has not been addressed, is that of proportionality. And that is what I will be focusing on, my lords. May I hand over my written submissions? May I please, fellows? My lords, I will not labor on the contours of proportionality. Your lordships are well aware of it. Suffice to say that it is a check, it is a test to check the fairness and reasonableness of any limitation or encroachment on any fundamental or constitutional right. And your lordships typically apply a four-layered structured analysis to test proportionality. That I've captured in paragraphs 1, 2, 3 of my written submissions, my lords. And in paragraph 4, I have captured the arguments of the petitioners. I will not read it. In short, their contention is that the SIR violates all prongs of proportionality. Now, my lords, before I address those contentions, there are three aspects which I would request your lordships to note. One is the ingredients of 326, my lords. In my respectful submission, 326 is in the nature of a self-limiting constitutional provision. It provides for adult suffrage, and it says that anybody who is entitled to be registered on the electoral rolls will be done. Now, 326 also contains three preconditions, which is citizenship, 18 years of age, and the elector should not be disqualified on grounds of unsoundness of mind, non-residence, etc. So, my lords, the submission is that under 326, the entitlement is a qualified right, and without providing proof of qualification, no person can be entered on the rolls. The second submission, my lords, is with respect to scope of 21. It has been dealt with extensively, so I will not labor on this. The only thing that I'll say is, my lords, the phrase "in such manner as it may think fit" should be afforded a wide and a liberal construction. And much like my senior Mr. Maninder Singh, if I may borrow Justice Bagchi's phraseology, what 21(3) does is it unshackles the Election Commission from the rigors of the RER 1960 to devise a mechanism and conduct revision in such manner as it may think fit. The third aspect, my lords, is the difference between a summary, intensive, and a special revision. That is at page 7 of my written submissions. That has been dealt with. The only point that I want to highlight is that under a summary and intensive revision, those are objection-based exercise. The lordships have already noted that. The only way to verify anybody's eligibility under those two forms of revisions is through Form 7. And except for, your lordships have seen Form 7, the burden is on the objector to prove that somebody is ineligible and should be removed from the rules. So barring aspects of perhaps somebody who's absent from the constituency or who is not of 18 years of age or is dead, aspects relating to citizenship, an objector will never be privy to. Because your lordships have seen in Sarbananda Sonowal 2, paragraph 61 and 62, I've cited that. This information is in the special knowledge of that person concerned. So that burden will never be able to be met under a special and under a summary and intensive revision under Rule 25. So therefore, if the idea is to check eligibility of all those electors who've not previously undergone an SIR, the only means available is through invoking 21(3). Now, I'll straight away come to proportionality. In fact, I will also not dwell on the first stage, which is the legitimate state aim. I don't think it's anybody's contention that a pure electoral roll does not serve a legitimate state aim. In fact, it is a core element of free and fair elections, which your lordships have held to be a part of the basic structure. This I have dealt with, my lords, from paragraphs 12 to 14. What your lordships may also note in this regard is that the decision to conduct the SIR was also taken in light of the irregularities which existed on the rolls. Along with the time gap, your lordships are aware that for 23 years from the previous SIR, no SIR was conducted. And add to that, my lords, the rapid urbanization, mass migrations reasons which have been recorded in the SIR order. So because of all these reasons, my lords, the decision was taken to conduct an SIR. It serves a legitimate state aim. The second stage, my lords, is the rational nexus stage. And at this stage, my lords, the inquiry is whether there is an increased likelihood of achieving the objective. That's the test that your lordships have delineated. It is not necessary at this stage, my lords, that the means adopted should be the only means of realizing the objective. But even if it partially achieves the objective, that will suffice the test. And I rely on, my lords, the electoral bond scheme case. I have cited paragraph 120. I will not read it. It is at page 11. Your lordships may consider. I have also relied upon Madhyamam broadcasting, paragraphs 116. I've put in the citation just below that. So let's just see how the SIR proceeds as far as rational nexus is concerned. It is a house-to-house enumeration exercise. Pre-filled individual specific, this is very important, individual specific forms are given to each existing elector. All they have to do is they have to affix their signatures, and then those forms are collected and uploaded by the BLO. So the enumeration phase itself serves as the first stage of filtration, because anybody who's absent, who's dead, who's shifted, his form will not come in, and they will be excluded from the draft rolls. That's the first stage of filtration, first stage of nexus with the object. Subsequently, my lords, all three criteria of all those individuals who have not previously undergone a revision, special revision, will be verified. That's the second stage of filtration. So in short, my lords, it definitely has a nexus with the object of purification. And in fact, even if I were to demonstrate this with a reference to the figures, approximately 60-70 lakh individuals, irregular entries have been removed from the pre-existing electoral rolls, which shows that there is a direct bearing with the nexus. And it is an effective form of removing ineligible entries.
How do you apply proportionality principle here?
My lords, I'm grateful for that query. That's my second leg of submissions. Because, okay, then I will straight away come to that, because according to me, proportionality...
You can come to that point, rest you can leave.
Very well, my lords. Lords, I'm grateful for that query.
So just to close the loop, all the 4 stages of proportionality are satisfied, my lords. I've dealt with those aspects up till paragraph 27 of my written submissions. So, my lords, your lordships have identified, apropos your lordships query, if it applies at all or not. In modern dental, your lordships have identified a working definition of proportionality as the, if I may read it out, I've captured it in paragraph 28 of my written submissions. Proportionality as a set of rules determining the necessary and sufficient conditions or limitation of a constitutionally protected right by a law to be constitutionally permissible. Now, my lords, absent any limitation which is imposed by the ECI, where is the question of applying proportionality? The limitations flow from Article 326, read with Section 16 and 19 of the RP Act 1950. It is not the case that we have come up with a policy and increased the threshold of eligibility, which is not contained in the Constitution itself. All we are doing is that we are verifying the eligibility parameters. It is not that we have said that apart from the 3 criteria mentioned therein, you have to prove X also and Y also, only then you will be registered on the rules. So absent those limitations, my lords, there is no question of applying proportionality. That's my submission. In fact, at paragraph 31, my lords, I have provided a non-exhaustive set of 5 cases. In all these cases, wherever your lordships have applied proportionality, there was always an added imposition of a limitation. Absent that, there is no application of proportionality. I will not refer to it. Lordships may see it at a later stage.
So the points are almost covered.
Yes, my lords. I'll just take 2 more minutes and I'll close. The third submission on assessment of citizenship, again, it has been dealt with extensively. Your lordships have seen articles 102 and 103. Along those lines, there's one more statutory provision which has not been shown to your lordships, which is section 14 of the Government of Union Territories Act. Please have paragraph 37, my lords. If I may place that. Section 14 provides for disqualification of membership. And clause 1 says a person shall be disqualified for being chosen as and for being a member of the Legislative Assembly of the Union Territory. I'll skip subclause A and come to B. I've emboldened that. If he is for the time being disqualified for being chosen as and for being a member of either houses of parliament under provision subclause B and subclause C or subclause D. D is citizenship criteria. And at clause 4, my lords, before giving any decision on such a question, the president shall obtain the opinion of election commission which shall be binding. So this was one of the provisions which was not shown to your lordships. I've cited that. And at paragraph 38, I've extracted section 146 of the RP Act 1951, which vests judicial powers in the ECI to conduct such an inquiry. Lastly, my lords, at paragraph 39, I've cited 3 cases, 2 of which are constitution benches, which say that the opinion of the ECI is binding. In fact, your lordships may just mark NG Ranga's case, where it was held that even where a complaint is whimsical or frivolous, the president is obliged, or the governor, whatever the case may be, is obliged to send it across to the ECI, and it is ECI's prerogative to take a decision whether to initiate an inquiry or not. Well, these are my submissions. I'll close by saying that merely because in the name of an organization the term democratic exists does not mean that they are working towards strengthening the democratic fabric of this country. I'm very grateful for the patient hearing this.
Thank you. Mr. Acharya, 10 minutes tomorrow. No, not more than this.
Anything,
No, 10 minutes, that's all. No, nothing more.
able to do that. Then I'll give my written submissions to Lord Submit.
Rest you can give in writing.
I'm prepared, Lord. I will not be able
10 minutes only tomorrow.
Then consider.
I just need 1 minute time to say only something new. We are appearing
1 minute
from Bihar.
1 minute you take right now.
Let's see. Very well. We wanted to point out 2 things. As far as state of Bihar, we have filed a fresh writ petition praying for a mandamus to be issued to the EC to carry out an SIR revision as far as for both MLA and MLC elections. We've pointed out an order of the High Court of Bihar, Malats, where the High Court itself has taken cognizance of the fact that there are large-scale illegal immigrants who've come into Bihar. They were please create detention centers, and there are enough number of immigrants in the state of Bihar notified, assessed as such, home detention facilities have to be created. Therefore, the factum of large-scale immigration in Bihar is no longer in doubt. There are 8 districts which have porous border with Nepal and several others. Second, Malas, the Election Commission has conducted electoral roll revision for the MLC elections. Now, this, Malas, has not been informed to the Honorable Court that 15 to 26 deal with MLA elections, but 27 onwards deal with the election to MLCs. Lordship knows there are 6 states in India which have legislative councils, and elections for these legislative councils are held every 6 years. Now, Election Commission has been conducting the revision of rolls for teachers and students, graduate constituencies every 6 years before the election. In fact, currently as we speak, a revision is going on for elections in some seats scheduled in 26. But no revision was conducted for a period of 22 years as far as assembly elections are concerned. Therefore, we are praying, my lords, that your lordship may consider issuing a mandamus to the EC in terms of 21(2)(a). The words uses shall be revised. The Election Commission ought to comply with that mandate to consider revising the roll before every election, my lords, that takes place. And, my lords, done. That's it. Your lordship,
I will try to.
Assam SR,
We will give extra time tomorrow so that we can bind up with. Thank you. Thank you very much.
Welcome.